5, 4, 3, 2, 1. Good afternoon and welcome back to the Public Service Commission. We are continuing on docket number 2025-247E. All commissioners are present in the hearing room. It's my understanding Duke has another panel or more witnesses that they are getting ready to present.
Mr. Chair, good afternoon. The companies have sought to split up the presentation of their direct and rebuttal cases, so the company's direct case has concluded at this time.
All right. You can proceed. Everything is going to be at rebuttal. Okay. So we would go to SCSEBA.
SCSEBA's witness is Hamilton Davis.
Mr. Davis, if you'll raise your right hand, please.
Yes, ma'am.
Do you affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
I think it's all right. Bless you. Bless you. Mr. Davis, please state your name and business address. Am I on?
And you can move that microphone and pull it closer to you.
Okay.
Let's see if I can get it right. Hamilton Davis, 1519 King Street Extension, Charleston, South Carolina.
By whom are you employed and what capacity?
Energy Re as the Vice President of Regulatory Affairs.
Who are you testifying on behalf of today?
The Carolinas Clean Energy Business Association, or CCBA.
Are you aware that SCSEBA filed comments in this docket on February the 6th consisting of about 7 pages?
I am.
Are you familiar with that testimony?
I am.
Those comments.
I am.
Are you prepared today to adopt SCSEBA's comments into your testimony?
Yes.
Are you prepared today to answer questions about SCSEBA's comments?
I am.
Did you prepare or cause to be prepared direct testimony in this docket, also on February 6th, consisting of 4 pages?
Yes, I did.
Okay. Do you have any changes or corrections to that testimony?
No, I do not.
If I ask you the same questions today, would your answers be the same?
They would be.
Chair Powers, I would ask that the commission accepts SCSEBA's comments into the docket, and I also ask that the direct testimony of SCSEBA witness Davis be read into the record as if given orally from the stand.
Sorry. Pre-filed direct testimony of Mr. Hamilton Davis will be entered in the record as if given orally from the stand. The comments of SCSEBA will be marked and for identification placed in the record as exhibit number 4.
Thank you, Chair Powers. Mr. Davis, do you have a summary of your direct testimony which references SCSEBA's comments?
Yes, I do.
Can you present the summary?
Yes. Good afternoon, Commissioners. It's good to be here with you today. My name is Hamilton Davis. I currently serve as the Vice President of Regulatory Affairs for Energy Re, an independent clean energy and storage developer. I also serve on the board of CCBA, and I am chair of CCBA's Regulatory Committee. CCBA is a long-standing participant in South Carolina clean energy procurement proceedings, consistently advocating for robust competition from independent power producers, or IPPs, while recognizing that a balanced diversity of ownership between utilities and third parties can benefit customers and the grid. Although South Carolina's vertically integrated utility model has historically limited competition in electric generation, the General Assembly has carved out a space for competitive procurement of clean energy and storage under the Energy Security Act of 2025. That act requires that such resources be competitively procured and that ownership be reasonably balanced between utility-owned and third-party-owned resources. That statutory framework reflects legislative support for competition and ownership diversity without prescribing a rigid numerical formula. CCBA's comments in this docket emphasize 5 key points. First, competition brings value. CCBA emphasizes that competition from IPPs is critical to ensuring cost-effective resource development, fostering innovation, and diversifying risk allocation. Competitive markets allow developers to introduce advanced financing structures and new technologies to deliver low-cost products. Despite those advantages, it does not follow that utility-owned or utility-operated generation is inherently unreasonable. Rather, the prudence of specific utility costs should be evaluated in utility rate proceedings. Second, ownership diversity is advantageous. While competition is essential, CCBA acknowledges that different ownership structures offer distinct benefits, including risk diversification, financing flexibility, and broader economic development impacts in South Carolina. Utility-owned projects can mitigate execution risk during periods of market disruption because ratepayers, rather than developers, typically absorb cost increases or delays. Therefore, CCBA supports a reasoned regulatory approach that combines both IPP and utility ownership to facilitate orderly deployment of resources and to help utilities execute on their integrated resource plans. Third, a reasonable balance involves judgment. The 2025 Energy Security Act, in requiring a reasonable balance of independent and utility ownership, calls for the exercise of informed judgment rather than rigid formulaic compliance. A reasonable balance must consider both quantitative, e.g. cost and rate impacts, and more qualitative factors, e.g. reliability, operational control, and development risk. Reducing an ownership balance to a single metric risks oversimplifying a complex planning decision amid rapid technological and market change. Fourth, CCBA supports a multi-year perspective. The required reasonable balance of ownership should be evaluated across multiple procurements and over time, rather than enforced strictly within a single RFP cycle. Market dynamics, attrition rates, and competitive bids, and year-to-year variations all suggest that flexibility is necessary to achieve a balanced outcome in line with statutory intent. Fifth, a long-term balance should be even. CCBA believes that an approximate 50-50 ratio of utility-owned and IPP-owned solar and storage resources represents a reasonable policy guideline at present. Such a balance will help preserve competition, support utility execution discipline, manage risk, and sustain a diverse clean energy ecosystem in South Carolina. In conclusion, because the resources selected in the 2024 RFP generally accord with the above principles, CCBA supports approval of Duke's procurement. And this concludes my summary. Happy to answer questions.
Thank you. Chair Powers, he's available for questions.
Thank you, Mr. Twitt. Any questions from the company?
Yes, Mr. Chairman, I do have some questions. Good afternoon, Mr. Davis. How are you, sir?
I'm good. Good afternoon.
Thank you. I'm Brett Braceward. I'm an attorney for Duke Energy. I've got a few questions for you, and I really want to start focusing, I appreciate your summary there, on your role as a solar developer who participates in Duke's solar RFPs.
Mm-hmm.
I'd like to start out with your role in participating in the 2024 RFP. Energy RE, your employer, bid into that RFP. You submitted proposals into that request for proposal, if that's public information that you're comfortable sharing.
I probably little details I can share about the bids, but yes, we did bid into that RFP.
Okay, and I know that you personally participated in the stakeholder engagement that led up to that RFP process.
I have, as well as I believe every stakeholder process over probably the last 8 years that Duke's conducted as it's evolved this program over time.
Got it. So the 22 and the 23 CPRE programs that have been presented to this commission previously, you were involved in the development of those programs.
I was, and I've testified in some of those proceedings in the past as well.
Yes, sir, you have. And just in terms of the development of the 24 RFP that's before the commission today, would you agree that it substantially aligns in terms of structure with the 23 RFP that was before the commission last year?
Yeah, I think we continue to see adjustments made based on lessons learned and changes in the market. And so every year there are tweaks, but in terms of the overall structure and the general intent and execution, very similar between 23 and 24.
Thank you. And looking at the Duke RFP and based on the experience that you just explained and familiarity, would you agree that it's a well-designed framework both for stakeholder engagement as well as for implementing annual RFPs for solar and paired storage to procure the resources that I've identified in the 23 IRP?
Yeah, I mean, again, with the caveat, I think there are always lessons learned, and I think that this is an evolution in terms of getting it better and better, recognizing it will never be perfect, but given the stakeholder engagement and the contributions and participation of the solar industry in particular, I think we were quite comfortable with the design and the operation of the procurement in 24.
Thank you. And so one of the questions before the commission in this proceeding is whether there are benefits to continuing to pursue a dual state or multi-state procurement under subsection G that allows projects from both South Carolina and North Carolina to bid in and compete to meet the resource needs that are identified in the company's comprehensive IRP. As a developer and market participant who bids into those RFPs, would you say there are efficiencies and benefits for your company and for others of participating in that integrated balancing authority area-wide procurement across both South Carolina and North Carolina?
Yeah, I think that it would be. I think the inefficiency and the difficulty of managing multiple procurements versus one, just in and of itself, is a huge benefit, and we've got no concerns about the dual state multi-balancing and authority approach. We think it's worked well and will continue to.
Would you think that if you had to do a separate South Carolina only procurement or North Carolina only procurement, that would create potentially less of a bid pool for either procurement and would potentially lead to higher cost resources?
I think it would definitely change the volume of projects competing against one another and add complications regarding timing, things like interconnection study, alignment. I don't know, I don't know specifically whether it would drive cost up, but it certainly could have the potential to, given the reduced competition in each respective procurement between the two states.
Okay, thank you. So it is possible that it could increase costs, you would say?
It wouldn't surprise me if you saw less competitive results by diluting the procurements outside of a single procurement.
Thank you.
Yeah.
Are you familiar with the post-solicitation report that the independent evaluator, Charles River Associates, developed for the 24 RFP?
I am.
Okay, thank you. Pull on the screen here and see if this allows you to see it. All right. So I submit to you, this is application exhibit 2 of Duke Energy's application. This is the post-solicitation report. I appreciate that it says confidential at the top, but I'll represent to you the pages I have excerpted here are not confidential. Does that look familiar to you? And I can provide you a copy if that's helpful. I just have a few more general questions on it.
No, it's familiar.
Okay. And the intro framing here that the independent evaluator put forth of these Allegheny principles, which reflect a FERC established standard for best practices when you're establishing a solicitation for a fair, open, and transparent RFP. Are you familiar with these 4 principles of transparency, definition, evaluation, and oversight?
Yes, generally familiar with us.
Okay. And so Just touching on a few of these briefly, in your opinion, the RFP was transparent, open, and fair. There was equal information provided through the or the RFP website, and you had equal access to information.
That's accurate, yes.
Okay, and there was independent oversight, jumping to item 4, by the independent evaluator retained by Duke.
Yeah, I mean, I will say that because this has seemingly come up across multiple dockets, and I think somewhat in this docket too, this distinction between independent evaluators and independent administrators. And one of the design details that really matters for which one you're using is whether or not the IPP and utility ownership track are bundled together, or whether those are competing against one another versus individual tracks. Because they are individual tracks, the independent evaluator, I think, is an appropriate and adequate choice for independent oversight. To the extent that were changed, I think that an independent administrator would need to be considered so as to address the additional concerns that come up when you don't have those tracks separated in the way we currently do.
Okay, and that's today and in the past not been an issue for Duke. That they've been consistent in the way they've designed the RFP and the independent
Yes, it's been consistent through the CPRE processes. And if you go back to 2018, when those projects did compete head to head, an independent administrator was used. And when the design of the program changed, the choice of independent evaluator became reasonable and appropriate.
Understood. Thank you. All right, I want to move to number 2 and the definition of the products to be procured. And that's something that you might have heard Ms. Shirley Smith use the phrase product earlier, but it's clear that there's the product of a utility-owned resource, 35-year asset versus a 25-year PPA. Is that your understanding of the design of the RFP and the products that are being procured?
Yes.
Okay.
Those are 2 of the products being procured.
Fair enough. And we'll just put the solar panel storage
Yeah.
aside, since that doesn't appear to be in controversy.
Okay.
So in your role as a developer, you can bid into multiple tracks and provide a response for those products. You can bid a utility-owned project, or you can bid a 25-year PPA. But would you agree with me that in doing so, it's important to have well-defined targets for those products, meaning you have a target volume of utility-owned resources and a target volume of PPA bids that the utility is soliciting?
Yeah, I think total volume and understanding the general breakdown between the 2 tracks is both useful from a company perspective when preparing to bid in and deciding how to the strategy used to place those bids.
Okay. And if hypothetically the RFP just was saying we want to procure 1,000 megawatts and didn't give good definition of what was being solicited, as a developer, would you see that as more risky and potentially less certain?
I think the additional information, again, allows for individual companies to strategize around how they want to bid projects in. Often a company will bid in multiple projects. Some of those will be bid on the PPA track, some will be bid on the utility track, some will be bid in both. And so both the design and the transparency of the design informs how market participants engage in these procurements.
Okay, and if it's efficient for you to engage in the procurement, you can probably do so at a lower cost. Is that accurate?
Certainly, transparency and predictability allow higher confidence in cost, which generally leads to lower cost.
Okay, thank you. And in terms of the evaluation criteria that's being applied, the evaluation principle says that there should be standardized criteria that apply to all market participants equally, specify the criteria, both economic and non-economic, and the relative importance of each criteria. Is that your understanding of how the Duke RFP works?
Yes.
Okay. Just spend a little time with that. This is a submit to you another page from the IE's post-solicitation report that's explaining the bid evaluation framework. Does this look familiar to you?
It does.
Okay, and this is page for the transcript, page 15 of 34 of Exhibit 2. So in terms of the design of the Duke RFP, there is both a economic score as well as a non-economic score, as we just saw from the principle of evaluation that was discussed. Is that accurate?
It is.
Okay, thank you. And there's overall a 50-50 weighting in these scores, so getting to the lowest cost is a very important component of the bid evaluation process. And so this bid scoring accomplishes that through the 50% project's economics category. Agree with
Right.
that? And then it also assesses risk qualitatively, including development risk, technology risk, and other environmental factors that are considered in the bid evaluation process, and those are contributed to a weighting that adds up to 50%. Agree with that?
I do.
And would you agree that this balanced weighting of economic factors and non-economic factors together contributes to a reasonable scoring framework that gets to the highest rank, lowest cost portfolio of resources?
Yes.
And in contrast, if you just focused on economics without evaluating risk, you would get to a inferior portfolio of resources that would not reflect the evaluation criteria that we talked about a moment ago.
Yeah, I mean, I think these categories are in here for a reason, from the perspective of running a successful procurement that delivers viable projects that operate as intended to. And so having cost compared against and with these other risk and environmental type considerations is intended to identify the best projects that are bidding into the procurement.
So cost is important, but risk is also important. It's not the only criteria when you're completing this bid evaluation process.
Yeah, I mean, I think I make this reference in my testimony, and it applies to maybe a number of considerations in this docket where, this commission certainly is familiar with the balancing tests in the IRP. The reason we don't have we've moved in statute from this kind of notion of least cost, which is very difficult to determine because no one knows what the future holds, and you're dealing with different resources that have different attributes and different risk and different cost profiles over time. And so the balancing of these different considerations is, both the art and science of designing a good program.
Thank you. So want to turn now, if I could please, to your perspective on we think we talked about focusing on risk and not focusing purely on economics, but focusing on LCOE and how that's considered in the bid evaluation process and the scoring. So one of the issues, or maybe the only issue, frankly, in controversy in this proceeding is whether the LCOEs for certain projects that the ORS has identified that are on the PPA track, and their 25-year PPAs are lower than the utility-owned winners or finalists that were selected. And I think you spoke to this in your testimony and summary. But in terms of comparing relative economics, there is an issue between projects that were considered in step 2 of the bid evaluation process versus step 1. Are you familiar with the 2-step bid evaluation process that
Yes.
the companies undertake? And so would you agree with me that in determining the cost of a solar project that's bid into the RFP, there's really 2 big components. There's how much does it cost to build a solar plant, and then how much does it cost to upgrade the transmission system, which we call system upgrades or network upgrades, to make that interconnection?
Yeah, the interconnection cost, including network upgrades and the capital costs associated with the facility. And then if you're looking at it from a contract or overtime perspective, you have to consider things like O&M as well.
Sure, but that's kind of all baked into the PPA bid price, and then there's the upgrades, which are a separate component. Is that accurate? And so we just walked through the economic and non-economic scoring, and that, would you agree with me that that's all undertaken in step one of the bid evaluation process?
Yes, as I understand it.
Okay, we could just, so this is the RFP document itself, and so this makes very clear in the, call it the instruction manual to bidders of how the company is going to undertake and how the independent evaluator is going to review the process. And so it provides that step one, they'll perform initial ranking of proposals based on economic and non-economic criteria, but will not include system upgrade costs of estimates for projects in the resource solicitation cluster, or RSC. And so the RSC, you would agree with me, is the cluster study that's used for only projects that are in the RFP, a lot of acronyms here, to evaluate their upgrade cost.
Yes, used specific to the procurement for shortlisted projects.
Okay, shortlisted projects, that's a good phrase. And so in step two, the instructions 2 pages later, address that there'll be further evaluation, potentially reduction in the bid price through a refresh, but the real focus of step two is on those upgrade costs. That's what step two through the resource solicitation cluster identifies, correct?
That's correct.
Okay. And so if you are comparing LCOEs from the step one evaluation that didn't move to step two with projects that are finalists that went through step two and were studied through the resource solicitation cluster, those step one project LCOEs don't include a transmission cost component. That's just the project cost. Does that sound familiar to you? Does that intuitively make sense?
That is how I understand it, yeah.
Okay. And to make that comparison and all of the charts and tables in ORS's testimony, the relative percentages of differences, you're comparing apples to oranges in terms of the cost without transmission upgrades for the 3 PPA project proposals, or the 7 that they present in a table, with projects that have gone through the RSC and got to be a finalist. Would you agree with that based on your experience with the RFP?
I would say that if you're comparing a project that has not been evaluated through the interconnection process, and therefore you're not assuming any network upgrades, against projects that have gone through interconnection study and have been assigned network upgrades, then that is a bit of an apples to oranges comparison.
Okay, thank you. And so in addition to the independent evaluator's opinion, which he can present in the future, that it's not comparable to assess PPA projects against utility ownership track, there could potentially be significant cost implications of going through that cluster study that would change the economics of saying those step one PPA projects were more competitive than the utility-owned projects that were ultimately selected. Would you agree with that?
Well, I'm confused by the question.
Sure.
I mean, whether it's a PPA project or a utility-owned project, if you're comparing any of them to projects that haven't been evaluated from an interconnection standpoint, then you're not going to be comparing full cost to full cost.
That concur. Apologies, my question may have been confusing, but so in terms of what the transmission upgrade cost could be, those are range based on what your project's impacts to the system are, but they can potentially be significant. Would you agree with that?
Yeah, I think any procurement, not just Duke, but Santee's seen a lot of this as well. I was looking at one of their recent procurement results. There's always the potential, not always. I mean, either you're going to have them or you're not, right? But there are some projects will trigger significant network upgrades that makes those projects no longer competitive. Some will trigger network upgrades that are manageable and still leave the project competitive, and some will not trigger any. And until you do the interconnection evaluation, you won't know that.
Thank you. Mr. Chairman, I'd like to mark and identify one hearing exhibit, if I could, please. This would be DEC DEP cross-examination exhibit number 1. And so, you want to hand one to, and So it's a pretty thick document. I'm just going to use the first 2 pages of it. So the versions that I provided to the commission just are call it the summary section of the front, which is all I'm going to speak to briefly. But I've got the full document here that we'll provide to the court
Has it
reporter
been
for the record.
provided to all the parties before now?
We just provided it to the parties, yes, sir.
Any objection? Objection, ORS?
And I have the full document here if they want to review it, but I don't perceive it to be a concern.
We do not object.
Thank you.
Thank you.
The cluster study phase 1 report then will be exhibit number 5.
Thank you, sir. So, Mr. Davis, are you familiar with this document?
I don't know if I've seen this one specifically, but I've seen interconnection results before, so I'm familiar with the format.
Okay, so 2024 Resource Solicitation Cluster Study Phase 1. Would you accept, subject to check, or based on your recollection, that this cluster study report was produced by Duke Energy related to the 2024 RFP, and this is the study results for projects in Step 2, the secondary evaluation phase where they consider transmission cost?
It looks like that's what this is.
Okay, thank you. I thought you were in the weeds on transmission as well. I thought this would be one you would know.
I am. I just haven't. I
Okay.
just don't know that I've actually looked at this.
All right, well, if you'd flip over to what is page 3 of 29, please, sir.
I'm there.
All right, so we talked about in Step 1, there's an LCOE calculated based on the bid proposal, and there's a economic score, the LCOE plus the non-economic score. And then in Phase 2, they do this study, and it adds the transmission costs associated with the impacts of the system for these facilities. And so would you agree with me just looking at the first project there? That's a 74.9 megawatt proposed solar plus storage facility in Greenwood, County, South Carolina.
Yes.
And the assigned upgrade costs were $19.8 million.
Yes.
Okay, and just going down the page, we'll skip down to the third one. There is a proposed 60 megawatt solar facility in Lawrence County, South Carolina.
Yep.
And the total estimated upgrade costs there are $35.8 million.
See that?
Okay, and then a few more down, there's another 50 megawatt solar project in Lawrence County. That's the upgrades are $12.32 million.
Yes.
So I guess the point I'm trying to assess, and would you agree with that assigned network upgrades can significantly impact the LCOEs for a project once they progress to Step 2 and are evaluated for the full cost of the bid proposal?
Yeah, that's accurate.
Okay, thank you. That's all I have. Thank you, Mr. Chairman and
Yes,
Commissioners.
sir. Any questions from ORS?
No.
All right. Any commissioner questions? Commissioner Caston.
Just to kind of fill in the blanks, if I may, Mr. Davis. And good afternoon, by the way.
Good afternoon. How are you?
Fine, thank you. And having heard the questions and answers, this is, like I say, just to fill in the blanks. Relative to third-party solar facilities, all things equal, not the contract difference, but do third-party solar facilities have the same life expectancy as owner solar facilities?
Yeah, I think generally you're going to see a similar life expectancy across the industry for regards to who owns it. My understanding is, some companies will make different assumptions on facility life based on things like repaneling, replacement of inverters, and so it isn't as though you build it and then it operates for a certain term without any additional investment or maintenance. And depending on how companies plan to finance and make those changes over time will potentially implicate the total life expectancy of any given facility. But on the front end, generally, there is a life expectancy associated with that, absent those other caveats I just put on the table.
Okay, thank you. are the third-party solar facilities I guess less safe or less reliable, or are they equally reliable as owner?
I think that's a company to company issue, right? Like some utilities are more or less reliable than other utilities. Some developers are more or less reliable than other developers. The design of the facility, the components used, the operations and maintenance approach and investments that are taken, all those have implications for the availability and the efficiency of the facility. I think it's part of the non-economic scoring that's done through the procurement process, is to ensure you have bidders that are competent to deliver on the product that they have signed up for. And then in addition to that, within the PPAs, there are penalties for non-performance or PPA cancellation that also are attempted, an attempt to ensure that the folks that ultimately execute those contracts deliver on what they're agreeing to deliver on.
So what I think I heard, and you tell me if this is a good summary, it's not universal. It depends on the third party, how good they are, their credibility, and the electric utility, how good they are in their credibility. So it's not universal.
I think that's correct.
And I've heard the discussion about risk. Are third-party solar facilities at greater risk to the grid and South Carolina customers than utility-owned solar facilities?
From what perspective? From an operational perspective, or?
Well, let me start with that question, because that was a question I had. Like, I've heard the risk talked about, and I guess I've heard some aspect of it mentioned, but what are the risks? Can you, I guess, list them or tell me what some of the risks are?
When I think about risk from the
thinking in terms of economic and non-economic, and the non-economic, we're considering risk and such as that. What are the risks?
The various risks. So I think one of the topics that got a good bit of discussion in the various filed testimonies and comments in this docket has to do with kind of execution risk on the front end. And so as independent power producers, we are dealing with the market as it exists and the uncertainties that come about there. As was pointed out in this procurement in 2024, there was some expectation that we were going to see new tariffs levied, that there was potentially going to be a change in the investment tax credit. And all of those have implications for what the revenue requirements of a given facility would be. And not being able to perfectly forecast that means that I think in this instance, you saw a lot of folks walk away from bids because of the very quickly changing economic environment that we were dealing with at that point in time. And so that's one of the risks that's out there, that you see some attrition due to changes in the marketplace that were unforeseeable or unforeseen. The utility deals with that in a different way because they have the ability to still, if those cost changes are prudent, pass them along to ratepayers. And so essentially the assumed cost on the front end may end up being higher than anticipated. It could also be lower than anticipated. On the IPP side, we bid in a PPA price, and that's what we get. And so if the market changed and we bid lower than we should have, then we'll earn a lower return on that. But at certain points on the front end, things can change so dramatically that you're better just walking away from the bid altogether. And so we've seen different versions of that over time. In 2024 was tariffs, and the the change in the investment tax credit. In years prior, you've seen it from COVID and supply chains, from inflation, from workforce related issues, also different versions of tariffs that have shown up. So you have these macroeconomic or very specific policy regulatory type issues that arise. And so all of that injects a kind of uncertainty and risk into this process, and it shows up differently for IPPs versus the utility. As far as post-execution risk, I generally just I think of that as, again, are the owners of those facilities capitalized in a way to continue operating the facility as expected? And so they're liquidated damages and requirements within the PPA that are intended to ensure that. And generally, I think that's the job they do. Sometimes that doesn't happen. Sometimes you've got a company that doesn't live up to expectations. Again, sometimes you have utilities that don't live up to expectations, but I'm just trying to kind of give you a flavor of what this may look like. You thought this facility in year 10 was going to be producing 169,000 megawatt hours per year, and it's actually producing 150,000 megawatt hours per year. You got to go find that energy somewhere else. I don't think from a safety standpoint, reliability standpoint, from that perspective, I don't think there's much or any risk on that side of it, to the extent that these facilities are operating consistent with their interconnection agreements. So there are a few kind of examples that I think are responsive to your question. But I'm happy to elaborate or continue if you want to.
Well, let me
go there.
Let me make sure I got that first. That the various risks can be the front end. Can the third party do what they say they're going to do? And with the, I guess, prevailing policy of the day, whether the tax credits, not the tax credits, the effect it would have. And I think you said the post-execution risk, or would they be capitalized well enough to survive if they don't sell as much megawatt hours as they anticipated? Those are more non-economic risk. Is that?
Yeah, more performance risk.
And did I understand you to say that the utility does not have those issues?
No, I think the issues show up. I think all of these issues are present on the IPP and utility side, and I think the different business models require a different structure to accommodate them. And so on the IPP side, for instance, it's the terms and conditions within those PPAs. The utility doesn't have a PPA with itself. It's regulated by the commission. And so whether it's in rate cases or other informational filings that you all require, or whether it's through NERC or FERC, there's a different layer or a different version of oversight and compliance that they operate under versus an IPP. I would say both are designed to be effective and produce essentially reliable outcomes, and neither are perfect.
Okay. I think that's it. We live in an imperfect world, I think I just heard you say.
I think that's an understatement, Commissioner.
Thank you.
Thank you, Commissioner Casson. Any further commissioner questions?
Chair Powers.
Commissioner Williams.
Good to see you, Mr. Davis.
Good to see you.
I appreciated the conversation that you had with earlier with Attorney Bryceworth, and especially the testimony about independent evaluator versus independent administrator. I was going to ask about that, but I guess this is just a broad is there any takeaway that you have from this experience in terms of ways that this process could go better in the future?
In terms of this docket specifically, or the procurement process of
CPRA
designing procurement?
process, you know, as you've seen it evolve over time, it's more of a broad question, but but also based on the consternation that we've currently got going, considering. So I
definitely think there's going to be room for improvement, and I think it's why this process has been set up the way it has been, where we are on an annual basis doing stakeholder engagement. These programs are being filed with the commission so that you all have an opportunity to hear not just from the utility but from other parties. So I do expect that we'll get better at this. I will say that, you know, if you go to the Duke RFP website and look at, you know, the documents, just look at the form documents and the you know, the PPAs and everything that comes along with both bidding in and evaluating these procurements. It is insanely complicated. It's complicated in the way that like an IRP is complicated.
Okay.
And so I think of it as being a little bit like a puzzle where, or maybe it's Jenga too, some combination of the two, where it's not always obvious what role certain things are playing, but almost certainly if it's in there, it's connected to, you know, 3 other considerations, and all these things have been attempted to, you know, the attempt is to fit these different considerations, these pieces of the procurement design in a way that's producing, you know, good outcomes. That's, you know, from our perspective as IPPs, we want to have confidence coming in that we're in a competitive space that's being fairly evaluated, and to the extent that we're doing our job as an individual company and bringing a cost-effective, competitive product, that we have an opportunity to, you know, contract for that and build it. And that has been a, I mean, again, this is probably 6 years of procurement. I mean, Duke's been running these procurements since 2018. This current incarnation goes back to 2022, but this has been going on for a long time, and the industry has invested in a massive amount of time and thought and energy into getting this as close to right as we can get it and continuing to improve it. And so I think that we are well positioned to continue having, you know, these kind of annual reviews, and to the extent that we see design flaws and problems, you know, we are not shy about raising those concerns and bringing them to you all. I mean, we've had, you know, different experiences with different utilities in the state in that regard. But I think where we are with the Duke procurement right now reflects the fact that it's been, there's been a lot of time invested from a lot of different stakeholders, including the industry, and we are, you know, currently in a place that we think is a good one from a procurement design standpoint. And you know, we're just going to continue to be at the table, and as things change, we'll have new ideas and see where it goes.
In that vein, is there anything that the Public Service Commission can do differently to support the process?
I think to the extent that you guys have questions or want ex parte briefings on this issue, you know, let the parties know, because it's very hard to wrap your arms around, again, like the complexity of what's going on, what has been designed, what's going on here, how all this works, and, you know, what matters to us from an IPP standpoint, what matters to the regulators, whether it's ORS or the commissioners, what matters to the utility, and having to balance all of those, and recognizing that all of those are priorities and important. It's hard to do it, I think, in, you know, 37 pages of testimony that Duke filed, and, you know, brief follow-ups from CCBA. You're getting a very, I think, very small glimpse into the substance of what this procurement actually entails. And so, you know, it's up to y'all if you want to spend more time looking at it and thinking about it, but I'm sure the parties in the room would be happy to spend that time if it's helpful to you all in getting to the right answer here.
Thank you. I appreciate that answer and no further questions.
Mr. Vice Chair, do you have a question?
Yes, sir. Thank you, Mr. Chair. Good afternoon, Mr. Davis.
Good afternoon.
I appreciate your testimony. I'm just trying to wrap my head around the differences in positions between the utility and the Office of Regulatory Staff. Do you have any opinion about those differences based on what you've heard and your participation in this case up to this point?
I mean, I don't want to speak for the other parties. I think that, obviously we put our opinion on the record. I think that it's, I was reviewing the testimony from previous dockets, and this topic has come up a couple different times, and it's always come up in the context of the fact that it's complicated to address this ownership split issue, which I think generally is the rub here in this proceeding. And you look at the new South Carolina statute, and it says a reasonable split, which is not, it's not formulaic. It's not telling this commission exactly where you need to land, other than using your judgment as to what is reasonable. And I think what we've tried to do in our testimony is point out the different considerations, what we see as legitimate considerations, kind of competing value profiles of utility versus IPP, and establish the fact that we are comfortable at this point with, this approximate 50-50 split. And there are a lot of design considerations for the procurement that are implicated by whether or not there is a split. Again, for instance, if it's all just head-to-head and it's all just least cost, from a strict like LCOE perspective, that fundamentally changes some of the design and the considerations that need to be made in how these procurements run. And if that ends up being the commission's prerogative on this, it still has to comply with the law, but it does have fundamental, will have a fundamental impact on how to think about the design of this program. And I think from our perspective and from the perspective of, the IRP, what's assumed in the IRP from a cost standpoint and a resource availability and need standpoint, that these procurements have been well designed and are meeting the expectations that are established in those resource plans.
Thank you. That's all I have, Mr. Chair.
Thank you, Mr. Vice Chair. Any redirect?
No redirect. Chair Powers made. A witness be excused if he needs to leave.
At his own risk. Thank you, Mr. Witt. ORS.
Thank you, Commissioners.
Mr. Salter. ORS calls Finley Salter to the stand.
Mr. Salter, if you'll raise your right hand, please. Do you solemnly affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Please state your name and occupation. Give you a moment to get settled.
My name is James Finley Salter. I am employed by the state of South Carolina as the Deputy Director of Energy Planning and Emerging Technology Division at the Office of Regulatory Staff.
Mr. Salter, did you cause to be pre-filed in this docket 3 pages of direct testimony on February 6, 2026?
Yes, I did.
Do you have any changes or corrections to your pre-filed testimony?
No, I do not.
If I asked you today the same questions you posed in your direct testimony, would your answers be the same?
Yes.
Chair Powers, ORS asks that the pre-filed direct testimony of Mr. Salter be entered in the record of this case as if given orally from the stand.
The Pre-filed direct testimony, Mr. Salter, will be entered in the record as if given orally from the stand.
Mr. Salter, did you also pre-file one exhibit with your direct testimony marked as Exhibit JFS1, which included confidential and public versions?
Yes, I did.
Do you have any changes or corrections to your Exhibit JSF1?
No, I do not.
Chair Powers, RS asks that Mr. Salter's Exhibit JFS1 be entered into the record as the next hearing exhibit and that the confidential version remain under seal.
The pre-filed exhibit of witness Salter, identified as JFS-1, is marked for identification, will be placed in the record as Exhibit number 6. The confidential version of this exhibit shall remain confidential unless or until the Commission rules that such information is not entitled to protection from public disclosure, or if the requesting party agrees that such information is no longer confidential or proprietary.
Thank you. Thank you, Chair Powers. Mr. Salter, you have heard discussion today about information ORS did not receive from the companies related to its review. Is this correct?
Yes.
What information did the company provide to support the higher cost of utility-owned track applications?
I can read a couple of discovery responses that I refer to in my rebuttal testimony regarding questions that we asked of the company to try to justify the target ownership allocations that were used in this case. The first request was we requested the companies refer to the 55-45% split between utility ownership and controllable PPA track as a reasonable balance, and provide an explanation along with supporting work papers for how the companies determined this to be an appropriate ratio. The companies responded that a reasonable balance of ownership in this context means to the company approximately half and half. The company continues to discuss the half and half provides layer protection to customers, and that necessarily generation will be built, which is an important factor given the attrition seen from prior RFPs. The companies are seeking approval of this reasonable balance of contracted third-party utility solar resources so that we can appropriately balance cost, risks, and operational flexibility. And then the companies note the 2022 and 2023 procurements. In this case, the companies were not able to provide any type of work papers or analysis to justify the 55-45 or approximately half and half beyond some general statements made in response to discovery. And as a follow-up to that discovery request, ORS asked some more detailed questions, provide a detailed description of how the companies proposed the 55-45 ownership split ensures greater system reliability. In this case, the company pointed to some of the aspects that have been mentioned in the rebuttal testimony, including control, responsibility, commission oversight, end-of-life issues, and future technology evolutions and future system changes. Additionally, in the same set of questions, ORS asked, did the companies analyze other ownership split options, provide a detailed explanation of other ownership split options the company analyzed, and if not, why? And then provide supporting documentation and work papers. The company responded, and for the reasons specified in the prior two questions that I just read, the companies believe that a relatively even split between utility and third-party ownership provides the appropriate balance of resources moving forward. So I think the characterization that I've heard so far in this hearing, that the companies did respond to our questions. The companies did not provide an analysis or an evaluation to justify the target splits that were requested in this RFP. I hope that helps clear things up.
Thank you. Mr. Salter, did you prepare a summary of your direct testimony?
Yes, I did.
Could you present your summary to the Commission?
Chair Powers, Vice Chair Williams, and members of the Commission. My testimony summarizes the Office of Regulatory Staff's review of Duke Energy Carolinas and Duke Energy Progress 2024 competitive procurement of solar and solar paired with storage resources, the 2024 CPRE program. Duke Energy conducted a request for proposals, the 2024 RFP, seeking approximately 1,585 megawatts of solar and solar paired with storage, consistent with its approved Integrated Resource Plan, IRP. The 2024 RFP targeted 55% utility-owned tract projects and 45% third-party owned projects contracted under Controllable Power Purchase Agreements, PPAs. ORS reviewed the application, bid results, responses to data requests, and independent evaluator materials to determine whether the procurement results are in the public interest and support economic, reliable, and safe operations of the grid as required under South Carolina Code Annotated Section 584220G. From a cost perspective, ORS found consistent material price difference between utility-owned solar and third-party-owned PPA solar projects. ORS also examined which projects were selected and excluded throughout the 2024 RFP process. ORS noted several lower-cost third-party solar projects were excluded despite being more economical than higher-cost utility-owned projects. In its application, Duke Energy stated that project selection aligned with targeted allocation established pursuant North Carolina law, specifically House Bill 951. ORS determined Duke Energy did not quantify or justify the benefits of selecting higher-cost utility-owned projects, nor did it demonstrate that those benefits outweigh the additional cost to South Carolina customers. From a reliability perspective, ORS found Duke Energy's controllable PPAs are designed to mitigate performance and operational risk. Under these contracts, availability and performance risk is largely rests with the developer, while Duke Energy retains operational control rights, including curtailability authority. As a result, ORS did not find reliability or operational concerns that would justify paying material higher costs for utility ownership. ORS also reviewed recent fuel cost data and found that the levelized cost of certain utility-owned solar projects exceeded the highest average fuel cost currently experienced on Duke Energy's system, raising additional concerns about economic justification. Based on an alternative analysis that prioritized project economics rather than a predetermined ownership split, ORS determined that a higher share of controllable PPA projects would have resulted in a more economic portfolio and lower overall cost to South Carolina customers. As a result, ORS concludes that the selection of 3 specific utility-owned solar projects, Sandhill Solar, Mosley Creek, and Ponderosa Solar Center, are not in the public interest for South Carolina customers because those selections were driven by North Carolina policy requirements and result in unreasonable additional costs. ORS does not oppose approval of the remaining selected projects, including the selected utility-owned tract solar paired with storage projects. ORS recommends the Commission require Duke Energy to allocate the incremental costs and benefits associated with these higher cost utility-owned projects away from South Carolina customers. Additionally, Duke Energy should file for the Commission approval the method and calculations for such allocation and a cost estimate for the development and administration of the methodology. That concludes my summary.
Chair Powers, Commissioners, witness Salter is available for questions.
Thank you very much. Duke, any questions?
Good afternoon, Mr. Salter. How are you, sir?
Good afternoon. Doing well.
Brett Brightshort on behalf of Duke Energy. So want to start out, you added some new Q&A to your summary with counsel introducing your testimony related to the conversation, I presume, that came up this morning about the company's responsiveness to discovery. Is that accurate?
Yes, that's correct.
Okay. And you walked through a few kind of summary remarks about the company's responses to the discovery and the questions that ORS asked about both the data that the companies had in their possession related to this 2024 solar RFP that's before the commission, as well as some of the questions that ORS asked about how the company analyzed the ownership split. Is that fair?
That's correct.
Okay. Chair Powers, I think it would be helpful to the commission to give y'all a full picture of the discovery that was produced. And so I have a few questions that I'll ask Mr. Salter about this, but at this time the company would like to put the discovery requests that Mr. Salter generally referenced into the record as hearing exhibits. So if I could mark those as the next hearing exhibits, please. So the first set would be the company's response to ORS Set 1, which I believe Mr. Salter is familiar
I
with.
think everybody would have to see what it is.
Understood. I'm sorry, I was previewing that'll be about 4 exhibits here that I'm going to work through in the next minute or two.
Can we go ahead and get all 4 of them?
We absolutely can, yes, sir. So there's this is the company's responses to ORS Set 1. The date of responses were October 24th of 2025. And then the company's follow-on responses to ORS, I'm sorry, did you want to have that be a single exhibit?
Just let him go ahead and give us what you got.
Okay. So this is Set 2 here, which is the company's responses that were produced on November 12th of 2025. Then the
Any
company's response, sorry.
Any objection by either party?
No objection.
We're still reviewing what is before us and how these are to be presented. Will this be as one bundle of exhibits or each individual?
The chair's preference, I would recommend that we have 4 separate exhibits since there's 4 sets of discovery, if that pleases the commission.
All right.
So you want, if you'd like, I'd go through these one at a time, or however is your preference.
Do
Mr. Chair.
that for me.
Okay. So I'll start again with the company's responses to ORS's first set, which is or Set 1, which was provided on October 24th of 2025.
That will be exhibit number 7.
Thank you. And then Set 2 responses, which were provided on November 12th of 2025.
That will be exhibit number 8.
And then Set 3 responses, which were provided on November 20th, which have some redactions because there's confidential information, so not wanting to have confidential information in the record, we've redacted the responses, which are unrelated to the conversation planning to have with Mr. Salter that he had with the commission earlier.
All right, that'll be exhibit number 9.
Thank you. And then ORS's response, or the company's responses to ORS Set 4 requests that were produced on January 21st.
Exhibit number 10.
Thank you very much. Mr. Salter, do you have all 4 of those?
Pardon me a moment. Objection. Did Mr. Salter reference anything from DR Set 4?
I'm not sure if he did, but we produced the discovery, so I'd like to mark it as an exhibit.
Or from 3? Are you sure they were from 3 and 4, or you just?
I'm going to ask him a few questions about it, so I don't
Okay.
recall
No.
specifically. He didn't give
No.
specific numbers or references; it was more general. So
Objection. Based on he has not referenced it yet, and he hasn't covered these yet.
okay, I can authenticate it.
Go right ahead.
Oh, very good. Sorry, I lost the chair.
I'm sorry. I'm stepping in for the chair. I think.
Not a problem.
Yeah,
All right.
go
Thank
right
you,
ahead.
Vice Chair Williams. All right, Mr. Salter, you referenced earlier the responses that the company provided to your discovery, and just to confirm, this is this familiar to you? This is the company's responses to your set 1 discovery that was just entered as a hearing exhibit. This is pages showing the company's responses to 1-4 and 1-5 specifically. And I think you mentioned half and half earlier. That was the general discussion.
1-5 was the first question that I read. Sorry
Okay.
for not being more precise.
That's all right. Not a problem at all. Just all right. So I'd like to start briefly with 1-4, and just to confirm, you ORS asked the companies to provide all work papers, documentation used to develop the post-solicitation report, and the companies provided their master file, which contained all the detailed support for that post-solicitation report, including all the project support, the LCOEs, and other information the companies had related to the bid evaluation that was completed. Is that accurate?
That's correct.
Okay. And so that was all the data the company had in their files related to the bid evaluation process that was completed. Agree with that?
Yes, that was all the data. All that data was predicated on the target ownership split.
As was
Just
the
to,
RFP.
just to
correct.
clarify.
Understood.
Mhm.
And so in 1-5, the company provided a detailed explanation the first time to its view of how the ownership split was used and how that was consistent with a reasonable balance. And that's what you were referring to earlier, half and half.
That's correct, half and half.
Thank you. All right. Referring you to set 2 of the
Okay,
company's
so
responses. You have
we
that
good
there?
with 1?
Yes, sir. You
Okay.
can put that one down. All right. So in questions 2-2 and then 2-3, ORS asked the companies a number of related questions associated with the benefits to South Carolina of the selected portfolio of resources, and then also the justification again for the ownership split. Is that accurate in 2-2 and 2-3?
That's correct. But just to clarify, what I was reading, just for for everyone's knowledge, was from 2-3,
Okay.
or what I was sort of paraphrasing at the beginning. But I do see 2-2 as well.
Okay. And so the ORS followed up after the initial request, and the company responded again. And then you can put that one down, sir. And then I will refer you to set 3.
Set 3.
And I noted for the chairman that the first question was, or there was confidential information that has been redacted here, but that's not related to what we're focused on here. And so in 3-1, ORS again asked questions about the financial benefits and costs associated with these projects. Is that accurate?
That's correct.
Okay. And the company, so this is a follow-on to the same analysis that was being undertaken in sets 1 and 2.
That's correct.
And then about 4 months after the companies filed their application on January 14th, ORS asked set 4, and the company responded on January 21st.
I have a question about this exhibit.
Okay.
In my notes, this is one that was filed on January 21st. I've got a couple supplemental versions of this. I've got a supplemental version on January 23rd. I've got a supplemental version that was filed on January 26th. And yeah, I think that's the only supplements that I have, but just wanted to.
Okay. Well,
And
thank you.
22nd, January 22nd. So I got I got in my notes I have 3 supplements to go with this.
Very good. Well, that means
Okay.
they were extra responsive to this set, but those supplements don't relate to 4-3, which was, at least to the best of my knowledge, which is the focus of what I'd like to confirm. The companies, again, responded on the issue of the portfolio and why it was reasonable from a cost-effectiveness standpoint. So if you'd refer us to the bottom of page 3, this is question 4-3.
Page 4.
Bottom of 3, question 4-3.
Okay.
And throughout this whole process of sets 1, 2, 3, and 4, ORS has been asking the company essentially to quantify the benefits of these utility-owned projects and quantify the relative benefits of these utility-owned projects as compared to PPA projects based on the economics and the non-economic scores. Is that accurate?
Yes, sir. I mean, I think over the course of our review, as we looked at the substantial cost difference between the utility-owned projects and the power purchase agreements, we are trying to reconcile what are the additional benefits that these utility-owned projects convey, and how could they be justified? Like, how could they help justify the additional cost? That was the approach that we were taking there in this review, is to determine, are we missing some quantifiable benefits that we can take into account during our evaluation that can be sort of accounted for? I mean, we could read the general statements that were made in response to some of these discovery responses, but trying to sort of quantify that to justify the additional cost is what this line of questioning was intended to elicit a detailed response.
Okay, and at each step along the way, the company responded and provided both the documents and information, the data that was in their possession, as well as their feedback on why they responded substantively or provided their feedback on why they disagreed with the premise that there would be a quantitative analysis that would be undertaken related to the relative value of utility ownership versus a third-party PPA. Is that accurate?
Yes, and in 4.3, the companies objected to the request.
They did, yes, sir.
Mhm.
But then they responded notwithstanding the rejection and essentially said that based on the bid evaluation process, that the portfolio of resources was lower than the solar reference cost.
Objection. Is that the corrected response in supplemental response from January 22nd? There was a corrective response to 4.3 that was filed on January 22nd.
Yeah, we can move on, Mr. Chairman, but this is the original response, which I don't believe this statement changed to 4-3 that said that the LCOE, this is the last page, the last sentence, is 1% lower than the solar reference cost.
I'm going to sustain the objection, stick with whatever his response was.
Yes, sir, and that was the company's response. Thank you. So, Mr. Salter, one additional exhibit, if I could, Mr. Chairman. So this would be the company's responses to ORS's set 2, where we, and are you familiar with these discovery requests, Mr. Salter? And we can pass them out here momentarily.
Yeah, if you could pass them out, is this the discovery
Just wait
from
till the parties get a copy of it. Is there any objection from any party? Any objection from SEBA? Any objection from ORS?
No objection.
All right, that will be exhibit number 11.
Thank you, sir. So Are you familiar with these responses, Mr. Salter?
Yes, sir.
And many of them are objections, but I really want to focus on the response that ORS responded to question 2-7. If you could turn to that one, please. Let me know when you've had a chance to review it.
Oh, 2-7? Yes, sir.
Thank you. So after 4 rounds of ORS asking the company to quantitatively assess the relative benefits versus cost of utility-owned generation, utility-owned solar versus third-party, the companies asked ORS to identify any other utility procurement program, solar procurement program across the country where there was a similar quantitative or qualitative analysis that was prepared to similar to what the ORS was asking for to determine the relative allocation of utility ownership versus purchase power resources that would be identified and targeted in the RFP. Do you see that?
Yes. 2-7, right?
Yes, sir.
Identify any utility procurement program across the country, if any, where the utility relies upon quantitative or qualitative analysis similar to the analysis ORS alleges the company failed to provide.
That's right. And you reference Santee Cooper, which does not target utility ownership as your response. Do you see that?
Yes, I see that.
And you reference back to 2-6A, which was an objection to the company's request earlier on the page, and essentially said it wasn't your, as ORS's responsibility to, your responsibility, was to review the program and evaluate the results, not to propose modifications to the company's evaluation procedures. Do you see that?
That's correct.
Okay, and just to be clear, ORS has not identified other utilities that quantitatively analyze the relative procurements of utility-owned projects versus third-party projects when they're developing a solicitation. Qualitative approaches such as the company have presented in response to ORS in discovery and in testimony by Mr. George Brown, which we'll hear from today, is consistent with how other utilities have determined these policy judgments, as Mr. Davis mentioned earlier.
Objection on the same grounds we objected in our responses.
Objection sustained.
That's fine. I'd still like him to answer the question, please.
Could you repeat the question, please?
Sure. Did ORS identify any other utility across
Pardon
the
me,
country?
the objection was sustained.
It was.
So
Just move on to something else.
it's a factual question of whether he identified any other utilities across the country that do what he's asking Duke Energy to do in this docket. I understand that ORS is objecting on legal grounds that it's not their role to develop the procurement, but it seems material that they would be able to say whether they're aware of any other utility in the country that is quantitatively analyzing utility-owned versus third-party in the way they're alleging Duke has failed to do here. That seems to be an important point. If ORS is going to take the position that Duke has failed to do something, that they should say whether they're aware or not of any other utility in the country that is doing what they're asking Duke to do, respectfully. But if you sustain it,
I don't know if he knows, but
well, if he doesn't know, that's a great answer. That's perfectly appropriate.
I just don't see that much relevance to that.
Okay. Thank you, sir. All right. Mr. Salter, I'd like to move to another topic, if I could, please. So, in your comments that you sponsored in your direct testimony, the core analysis, let's say, was that there was a difference in the relative cost of the selected utility ownership track projects as compared to certain third-party PPA projects that were not progressed from step 1 of the bid evaluation process to step 2. Do you recall that?
Well, the initial sort of issue that was identified was just in the selection was the difference in cost in the 2 selected tracks. And that led us to further investigation as to what was the universe of bids that were actually available for the company to evaluate and select, which I think is what you were just referring to.
Understood. And so through the bid evaluation process the company did, they went from a bigger pool and looked at the kind of call it the 60 bids that were submitted by developers and by the utility, and then they culled that down. I think Mr. Davis called it a short list. Are you familiar with that term? Does that make sense to you?
The 60 number, I can't
Round numbers,
confirm that, but
45 is what they identified for the step 2 evaluation.
okay. I can't confirm the full numbers,
Okay.
those actual numbers.
Would you agree with me that based on the bid evaluation process, the step 1 evaluation is an economic assessment of the bid submitted and then a non-economic assessment of the qualitative risk considerations that I spoke with Mr. Davis about?
My understanding is that step 1 looks at essentially a short list based on the lower price projects. Those projects are selected to go to step 2, and in step 2 the company would apply the non-price criteria, the non-economic criteria.
Okay, small point, but in step 1, both the economic and non-economic criteria are evaluated. That's what this is. The RFP document here, the company submitted page 27 and 36 of Exhibit 1, and this is what we confirmed earlier, is evaluating economic and non-economic criteria to get to that initial scoring that gets you to step 2 of the process. Agree with that?
For the data that we reviewed, I did not see non-economic scoring criteria in step 1.
Okay.
I mean, I didn't see a score.
Yeah.
And that's actually one of the challenges in this evaluation was all we had was price. There was in the data that was provided by the company, there was, because it didn't make it to step 2, we never saw that non-price score. And so the projects that were identified in table 4 of the comments, the data that we had, there was no non-price score to go with them. So to the extent that wherever these fell on non-economic criteria, it appeared that because they didn't make it to step 2, that the non-economic criteria was not considered and scored.
Okay, and I don't have the specific data you reviewed, but perhaps Mr. Lee, who's here, or Ms. Farber can give feedback on that ranking and scoring process. But I've referred you now to the step 2 evaluation, which takes that initial shortlist and does the transmission study through the resource solicitation cluster. Do you see that?
In step 2 of the evaluation process, Duke evaluation team will utilize the refresh bid prices as well as interconnection information developed in RSC phase 1, including system upgrade cost allocations and interdependencies with other RSC facilities or with prior queued projects.
So there's a transmission study, a cluster study that's done in step 2, and that identifies what the assigned costs are to interconnect the facility. Agree with that?
Yes.
Okay, so your comments and the ORS's position is that you did not support the utility-owned projects because they were, to keep out of confidential, materially more expensive in the ORS's view than the PPA proposals that you said were not considered, those LCOEs, which were based on the step 1 analysis. You agree with that?
What we recommended was an allocation of the higher cost utility projects away from South Carolina customers, because in our view, there was an opportunity for the company to select lower cost projects to serve South Carolina customers that was not taken advantage of to meet the targets.
But you would agree with me that those lower cost projects you're hypothesizing could have been selected were not studied in step 2. So we don't know what their transmission costs were. We don't know how much lower cost they were. Would you agree with that?
Yeah, and I think there's a distinction too, that the PPA projects bid in, see if I can get this right, a cost per megawatt hour per $1 million of upgrades. So there is some, they do have to bid in something to capture the final network upgrades that end up being applied to the project.
There is a metric used to translate their assigned upgrade costs to $1 per megawatt hour that's then added to their PPA price. But would you agree with me that we don't know what that is until we get to step 2?
Right. You don't know what that is until you get to step 2.
Because they haven't been studied for transmission cost.
Right.
And so as we discussed with Mr. Davis earlier, the transmission cost, I'm not sure if y'all can see back on the screen here, but were material in terms of projects in South Carolina that were studied in the same step 2 cluster study that was used to select the projects, to select the winners, both the PPA projects and the utility-owned projects in this RFP. You agree
Are you
with that?
saying the projects in table 4 of my comments had material?
Yes, sir. I'm saying the projects in table 4 of your, I need to double check table 4, but if those are the 7 projects you identified, they don't have any transmission costs with them.
But you're saying that you determined that there's material transmission costs
I've
associated
not done
with
the
them?
analysis. No, sir.
Okay.
I'm saying we don't know the answer to that. And
Right.
so your percentages of increases and the comparison is apples to oranges, because there's
Right.
project LCOEs, but not transmission LCOEs. Would you agree with that?
Well, I would agree that we don't know what the transmission costs are, because my understanding is once these projects weren't selected to go to step 2, that they withdrew themselves from the resource solicitation cluster and were no longer studied.
That's correct. They were never entered in the resource solicitation cluster, but ORS's recommendation is to direct generation away from South Carolina based on the premise, exclusively it appears, of only having higher LCOEs for utility-owned projects based on a comparison that's not accurate and is not apples to apples, because we don't know the transmission costs.
Is that a question?
Would you agree with that?
Could you restrict?
Objection, please make a question.
Would you agree with the statement that ORS is,
Sustained. You testify now.
yes,
Mr.
sir.
President.
Mr. Salter, would you agree with the statement that ORS's analysis and the table that you identified a moment ago, table 4, and those projects from step 1, you present a comparison saying those projects were lower cost than the utility-owned projects that were selected, and the premise of that is that there is a apples-to-apples comparison between the two. You've got the project cost LOEs plus the transmission cost LCOEs, and that's not an accurate comparison because we don't know what the transmission costs were for those projects because they weren't studied. Would you agree with that statement?
They could have been lower cost, but they weren't fully evaluated to determine A, what the transmission upgrade costs, or B, what the non-price factors would have been or could have been in step 2 of the evaluation. That's my answer.
So they okay, I'll leave it at that. Thank you, Mr. Chairman. Thank you, Mr. Salter.
Thank you. Any questions from Sasiba?
No questions.
Thank you. Commissioner questions? Oh, I'm sorry.
Chair Powers, before Commissioner questions, I believe you sustained my objection to let me see here, among all these new hearing exhibits, the non-corrected filing, let's see, DR believe it was DR 9 that had the corrected filing. Is a result of the sustained objection that the question is removed, or that the hearing exhibit is removed or substituted?
I think that was when Mr. Vice Chair was in charge at the moment.
Correct. It was Exhibit 10 for clarity. Yes.
The company's counsel was authenticating the document during that time, but I'm not sure what your objection was.
He was putting forward the uncorrected set of their responses to our questions. Therefore, the corrected response was not put forward, implying an incorrect response was put forward.
I mean, do you have the corrected response?
I have it in my binder. I don't have a set of printouts the way the company had prepared. I could bring it up if you'd like.
Yeah, all I have is, I mean, you have the same thing I have.
Yes, sir.
So you're saying is,
Ms.
One moment.
We'd be glad to either withdraw the exhibit or we can provide a corrected version of the exhibit if that's.
I think providing the corrected version would do the trick.
Yes, sir.
Okay, or Oris is fine with withdrawing as well. Okay.
I mean, with all due respect, is your objection what?
We'd prefer withdrawal, please, respectfully.
Okay. And you offered to enter into evidence. He wants you. Are you withdrawing your objection? No, you don't want the document into evidence, right?
Right.
Right.
Is that 3 or is it 4?
Counsel, you want the document into evidence.
We would be glad for it to be into evidence. If it is more efficient to withdraw that set 4, which was the exhibit at issue, then we will withdraw the exhibit and we can enter it in at a later time once corrected.
All right, that's fine. This would your objection is sustained. The
Thank you very
document is
much.
withdrawn.
Thank you, Mr. Vice Chair. Any commissioner questions? I have a question. Commissioner Britt.
Mr. Davis, what is the difference in cost between the UOT and the PPA that you keep talking about in this particular case on the 3 solar projects?
For the 3 specific solar projects, or for the selected portfolio,
Excuse
Commissioner?
me, I think-
Salter, not Davis.
And
Yeah,
sorry.
you keep referencing this difference in your
Mhm.
in your testimony. Maybe it's all of them. What is the cost that you keep getting at between a UOT and a PPA?
And
Chair
Mr.
Powers,
Chairman,
is-
Objection
may-
confidential.
Yes, thank you,
All right,
Mr.
that's what
Rasmussen.
yeah.
Just
If
for
it is confidential, yeah,
for
you can't
yes,
answer.
and we definitely want you to have the information that you need to make an informed decision. So if Mr. Salter can point to information in the testimony without having it on the record of what is confidential, we think that would be fine and protected. Or we can go into confidential session if that's helpful to the commissioner to get the information he needs.
Thank you, Mr. Salter. If you can do that.
Commissioner Britt, I can refer you to the testimony. Do you have Exhibit JFS1 in front of you? It's got a dark green highlight all over it.
No, I do not have it in front of me.
Do you have?
I have it though, but I don't have it in front of me.
If you look at, well, do you want me to wait for you to get it in front of you? Table 1, Commissioner Britt, is labeled Duke Energy 2024 RFP weighted average LCOE price results. When I was discussing earlier about sort of how we initially approached this case, this is essentially the first calculation that we did. Or, I mean, really, it was the company's results that we just sort of compared. We've done similar calculations in the 2023 IRP report. We saw results that are directionally the same as the results here. I won't say they're exact, but directionally. Are you able to see that table,
Yeah.
Commissioner? Let's see here. If you look at table 12, which is on page 10, this is labeled solar only project comparison. There was on the left side, Sandhills, Mosley, and Ponderosa are the utility owned projects. We looked at sort of comparable PPA projects that were not progressed to step 2. They were not invited to step 2 of the evaluation, which you heard me discussing with company's counsel. And then on the far right, you'll see the percent difference.
Chair Powers, if I might ask something. I can't see what you're holding in your left hand.
He has it.
I'm on table 12.
No, my point being, and I don't want to be overly cautious, but I don't want to be underly cautious, is that if it was anything confidential, I'm not sure someone could take a picture of that and blow it up. So
No.
I guess it's just the way the camera is. Just being overly cautious, if I may. That's all.
Appreciate it. Well, I think unless there's any follow-up, I think those are two. I think that addresses question.
Mr. Salters, I look at that chart, comparing them, I got to keep in mind what the real Mr. Davis that I was referring to earlier, when he talked about the transmission cost in his testimony may not be in this. Is that right?
Right. These projects were not the PPA projects were not. They withdrew
They didn't get stepped.
from the transmission study because they did not make it to step 2.
Gotcha. All right. That's helpful. I appreciate it.
Yeah.
Commissioner Belser, did
Yes, sir. Good afternoon, Mr. Salter.
Good afternoon.
Does ORS object to the way that the RFP is structured with a PPA track and a utility-owned track?
Oh, I want to be careful because we don't want to rewrite the company's processes. And so I don't know what could be done off the top of my head to compare, but at the end of the day,
Mr. Salter, I've asked a yes or no question. I would ask the response be yes, no, or I don't know, and then you can explain.
no.
Okay. Do you want to explain further?
As I discussed in my testimony, it's not that there's 2 tracks, it's the target of each track being set and then decisions being made subsequent to that target being set that, for instance, excludes projects that may have been economical and more cost effective for customers. So it's not necessarily that there's 2 tracks, it's the target that is predetermined on those tracks. And we believe that taking economics into consideration, in addition to the non-price factors, should influence where the final ownership balance lies at the end of the evaluation.
Given that the RFP was designed with those percentages, and I understand that you take exception to that, okay? So this is somewhat of a hypothetical. As you go through the RFP process, and let me just admit, you're going to know a lot more about this than I do, okay? As we have heard, and as it's come forth in the testimony, the number that initially bids in dwindles for various reasons, correct? Some because they may not make it to the next step, some because the PPA or somebody has gone out of business, or they can't get the financing, or whatever the reason may be. There are a number of reasons. I can't even think of all of them. But there'll be projects that fall out, correct?
That's correct.
Okay. So what happens when the projects winnow down or fall out such that even if it was a 50-50 split, that there isn't sufficient viable projects left to even meet the 50-50 split? Is there a problem that one track gets more than what was originally intended?
No.
Okay.
Our position is we don't have a predetermined split, but the economics and non-economic factors should be weighed and scored and evaluated, and that should determine what the actual ownership split ends up being. The evaluation should be fairly agnostic from an analysis standpoint to the ownership. If utility-owned projects have non-price benefits that help South Carolina customers and support the safe and reliable operation of the grid, by all means, those should be weighed properly in the non-price score and should influence the final decision on the suite of projects at the end of the RFP. I mean, even in this procurement, the company targeted the 55-45 that we've talked about and ended up with 64% utility owned and 36% PPA. So, I mean, obviously the target is not, a hard cap or a quota. I hope that answers your question.
It does.
Yeah.
It does. I mean, and that's kind of where I was going, is because what was originally set and then what ended up being was different.
That's correct.
So, thank you. Appreciate your responses, Mr. Salter. Thank you. Thank you, Mr. Chairman.
Thank you, Commissioner Belcher.
Chair Powell,
Commissioner Cast.
thank you. It's been an informative day, I think. I think I followed most of it. And what I think I just heard in that discussion with Vice Chair Belcher also is it's not it's not the ratio, it's not the percentage, whether X amounts utility owned or a third party.
Mm-hmm.
But whichever it is it still in the best interest for the South Carolina customer? Is that a fair?
I think ensuring that all benefits are considered, we agree that the highest scoring projects should be selected. Our concern is that when we reviewed the underlying data, there were projects with lower bids that were excluded from the subsequent evaluation, step 2 of the evaluation. And because the company made the decision to exclude those projects, that from what the company told us, they didn't withdraw. What they told us in response to discovery was we had 2.5 times the megawatts that we targeted for PPAs, so we didn't invite these projects to continue because we felt like we had, my words, more than enough megawatts in the PPA track. Sorry, go ahead. What ended up happening was there was this policy uncertainty that was described this morning. And what looks like happened was a number of projects that had been invited to step 2 ended up withdrawing. And in fact, at the end of the day, the company didn't end up meeting the solar only target that was set at the beginning of the RFP. But yet at step 1, they decided they had enough megawatts and they didn't need to invite any more to step 2.
And I understand I heard your comment where you said something along the lines that ORS isn't trying to, I guess, blow up the process or methodology or something like that for the CPRE. Is that?
I don't think I said blow up,
well,
Commissioner.
I don't remember what you said either.
Just correct the record.
But it seems like that there's something lacking in whatever the metrics are or the understanding. Ms. Smith, earlier you may have heard, said she felt like perhaps ORS and the company were talking past each other. Do you agree with that?
Well, I mean, I believe the company responded with their position. We were asking for justification. The response, and that's why I was trying to sort of color the discovery a little for you, is that their response was essentially, here's some broad general concepts, and we don't have any further analysis to justify it.
So would it be helpful to ORS if in the economic and non-economic benefits or costs, if there were some tangible, measurable, or something that you could put your finger on, you being ORS, would that be helpful?
Yes, and that's why we asked for quantitative data to justify and support the assertions made by the company.
I don't want to put words in Duke's mouth. I'm not sure they said that they did that, but they said they provided, they think, adequate information. ORS says they did not. Is there a path forward, if not this one, in the future, to help ameliorate that? Is it possible for ORS, either in the stakeholder process, outside the stakeholder process, to better define what these things may be?
I think if the company can provide a detailed analysis, take into consideration the price and non-price factors of utility-owned projects and power purchase agreements analyzed together to justify what the final selections are, then that would justify the results of the RFP.
All right. And finally, I'd ask, Duke went this earlier, about 58-42-10D. Do you agree, or does ORS agree, that the utility has the option to use all source generation in a CPRE rather than just a specific generation type?
I will address your question, but just to clarify, the company filed for this request under 584220G, which says notwithstanding the requirements of 584210. However, I think your question was around, does the does the companies at some point in the future have the ability to file an all source procurement? And I would agree that yes, they have the ability to file an all source procurement. They also have the ability to file a capacity procurement. Say the companies identify the need for dispatchable resources in their IRP, such as CTs at a certain date or even a combined cycle. The company has the ability to file a capacity request for procurement and have independent power producers bid in to that type of procurement request.
So if hypothetically, if it were an all-source CPRE, would that allow a greater opportunity to evaluate cost, reliability, construction times, risk, and such?
I believe an all-source procurement would take into account more technologies, which might have a different array of benefits and costs besides this very focused CPRE that the company requested here.
Okay. I think that's it. Thank you.
Thank you, Commissioner Cassidy.
Chair Powers.
Commissioner Williams.
Good afternoon.
Good afternoon.
I will not make the same statement that my colleague made about what I understand and don't understand. But let me start with kind of rolling back the clock. Did ORS participate in the stakeholder process that led to Duke's CPRE process?
ORS generally participates in Duke stakeholder engagements as we can. I mean, there's a lot of stakeholdering going on.
And I'm appreciative of both your answer and the fact that there's a lot of stakeholdering going on. So I wondered, particularly if you had articulated your concerns about the lack of a score to come out of step 1 and the methodology target of 55-45%.
Well, to your first question, I don't think we quite understood until we actually delved into this docket, and I guess the company indicated there is some type of non-price scoring, though we didn't see it in our review in step 1. So we didn't really understand that distinction until we actually reviewed the case that was in front of us. Regarding the 55-45, in the 2023 CPRE case, ORS has brought this issue up. In the 2023 IRP, the company or ORS has brought this issue up, and in I think it's some of the consumer renewables programs, we brought this up. I think it's the Clean Energy Connect program. We brought this issue of the 55-45 target from North Carolina law up, and in that program, the company was or is using CEEAs, which are basically RECs, clean energy attributes from PPAs and utility-owned projects in a community solar type fashion. And so the 55-45 was brought up in that one as well. So to answer your question, it's been brought up in several different arenas in front of the commission.
Well, that leads me to your table 12, which I know the numbers, but how do I look at those numbers from a consumer impact? How do you multiply them? What are the factors? I can see, relatively what the price points are, but conceptually, I don't understand how to use them. Can you help me understand?
So I'm glad you brought this up because, I wish I could just spit out what the revenue requirement impact would be or what the impact to a residential consumer would be, but we just didn't have enough data in this case to do it. So this was the best we could do as far as putting forward a magnitude of impact of the difference here. You would need to have an assumption about what the total production out of these facilities would be on a yearly basis. And multiply the UOT minus PPA LCOE difference. And that would essentially be maybe a very, very rough version of what the cost would be. I mean, these utility-owned projects don't include return. So they don't include weighted average cost of capital when the company puts these into rate base. So that's something that's missing. But the point of LCOE, which I try to talk a little bit about in my rebuttal, is, to sort of bring, the best way to levelize the cost of these different types of projects in a comparable fashion. I hope that helps.
It did. I have, I think, 2 more questions, so maybe 3. As ORS looked at this, did you all consider a path to support Duke's selected projects, but without the commission approving any cost, the cost differential? And I don't even think the cost differential is before us today, but did you explore that option?
Well, that's an interesting question, because that was sort of my understanding of the past CPRE settlements that occurred, was that program was, approved, but the projects would be reviewed in each rate case as they're put into rate base, or either for PPAs as they flow through to fuel, or else would look at them for reasonableness and prudence and provide y'all with recommendations in the requisite hearings or proceedings. But Act 41, and specifically 584220G, and I know the council stated this a couple times for you this morning. After the notwithstanding the requirements of 584210 in this section, the commission shall approve an electric utilities competitive procurement of energy storage facilities or renewable energy resources and the output of the energy storage facilities or renewable energy resources within an electrical utilities balancing area outside of South Carolina that serve customers within South Carolina if the eligible energy storage facilities or renewable energy resources located within South Carolina were allowed to participate in the competitive procurement, and if the commission determines that such results of such procurement are in the public interest and enable the economic, reliable, and safe operation of the grid. That was all one sentence. So here the statute specifically talks about, and I'm not a lawyer, so I'm just reading it, but it talks about approving the
Mr. Chairman,
procurement.
We would object if the witness who has agreed or conceded that he's not an attorney is construing the statutory meaning of the statute, which the commission had oral argument on this morning. So to the extent he's rendering a legal opinion or construing the statute, we would object.
Chair Powers, he's just doing his plain language interpretation.
I'm not sure what that means, Mr. Chairman. If everyone,
Just what the words mean as a regulator.
I think he's just answering the question. I mean, we can take it for what it's worth.
I can try to be more succinct. I mean, essentially, the statute has changed. The statutes have changed since Act 41 is passed, and there's different requirements now than there were in past CPREs. And we're trying to take those into consideration and comply with the law accordingly.
Is it your belief that if we approve this CPRE, we are making a prudency determination?
I think there's still an opportunity, and I think the companies acknowledge this in their application. There's an opportunity to review prudency of the cost incurred in a rate proceeding.
I asked this question of Mr. Davis, but any lessons learned that you want to tackle at this point for the future CPRE process?
Well, I'm glad you asked because we do have a recommendation. Oh, sorry, I'm trying to read through this color here. Hold on a second.
Yes, please understand, we were having great difficulty trying to read through that color as well.
One of our final recommendations is that in future CPRE solicitations, the company should evaluate the reasonable balance of ownership of the eligible facilities based on South Carolina law without regard to another state's jurisdictional policy or law prior to evaluating the competitive prices of the bids.
Just for understanding, is that the second of the two green paragraphs on page 11?
That's actually outside of the green.
Oh,
That's why I was having trouble finding it. That was in
it's at the very bottom of
starting
page
it
11.
additionally on page 11.
Got it.
And on to 12.
That's helpful. Thank you.
Right.
Chair Powers, that concludes my questions.
Thank you. Any further commissioner questions? Commissioner Thomas.
Thank you. So basically, there's been a lot of talk about cost and higher costs, and talk about other proceedings, the rate cases and fuel proceedings. And I just wanted to know, do you believe that in the other proceedings, such as a rate case or a fuel proceeding, that there are sufficient guardrails there to protect South Carolina customers from the higher costs that ORS has been talking about?
My personal view is that to the extent that utility-owned projects that are selected in this RFP are approved in this proceeding, to the extent that those projects are executed in line with the costs that are assumed in these bids, it's going to be sort of just sort of thinking about how that would happen, it'd be hard to see how, those costs would go down in a rate case. For just where I'm sitting, the company might know something different, but that's just sort of how I'd see the utility projects. Now, to the extent that the projects increase in budget, cost, review those cost increases, determine whether reasonable management decisions were made at the time that they're requested for recovery, there's opportunity there. But to the extent that these projects are approved here, I think my understanding is, this would approve the projects.
So it sounds to me like what I believe you're saying is that if these costs that you all have identified that are higher cost, if this is approved at this point, then there isn't much that can happen in a rate case to keep those costs from flowing through to customers. Is that more or less what you said?
Yeah, I don't want to never say never, but I think it would be difficult for these costs to be any lower than what were presented here.
Okay. And with regard to costs that would flow through a fuel proceeding, would those be pretty much have to flow through, or?
To the extent that the independent power producers, the third parties, produce the power and deliver it to the company, those costs I would expect them to flow through the fuel adjustment clause proceeding. To the extent that they may not produce power, or if there's some type of attrition between now and when they come online, those costs would not be flowed through fuel. So I think what's been discussed I think a couple of the prior witnesses, that in the case of the controllable PPAs, the third-party developer retains the risk of actually developing the project.
All right, thank you. I appreciate it.
Thank you, Commissioner Thomas. Any further commissioner questions? Any redirect?
Yes, yes, Chairman Powers. Mr. Salter, hello.
Hello.
Do you recall counsel for the companies discussing the bid evaluation report?
The independent evaluator report?
Yes, independent bid evaluation report, yes.
Yes.
Did the bid evaluation data include an analysis of the benefits of the higher cost UOT projects?
No, they did not.
Further, if the 55-45 split required by North Carolina Bill 951 were removed from the initial screen on the front end, do you think that would be a step to ameliorate this process?
Yes.
Thank you. No further questions.
Thank you, sir. Based upon that, any further questions? All right, you may step down. It is 3:45. We're going to take a quick 10-minute break, and when we come back, if the next witnesses
Chair
can
Powers, may witness Salter be excused?
Excuse me?
May witness Salter be excused?
Yes, he may.
Until the next phase.
There's one other thing, though. He was responding to some questions by referring to footnotes in his surrebuttal testimony. Did you want to proceed to enter that surrebuttal testimony? Or not? It's up to you.
We intend to, review that coming up. That was to help sort of, which items did he mention from his footnotes in his surrebuttal?
It was the response.
He referenced footnotes, excuse me, Mr. Chairman, he referenced footnotes in his opening soliloquy that brought forth his surrebuttal before he even got into his direct. That was what I was looking at.
Understood.
Is he coming back up?
Yes.
That'll...
He will be back up to testify to his surrebuttal.
Fine. All right, we're going to take a quick 10-minute break, and if the next witnesses can be in place, we'd appreciate it. Thank you. We're in recess. Good afternoon again. We are back on the record in docket number 2025-247-E. We are here now for some responsive testimony on behalf of the company.
Thank you, Mr. Chairman. Good afternoon, Brett Bracewart. The company calls back to the stand Ms. Mara Farver, as well as for his first appearance today in the rebuttal phase, Mr. George Brown. Ms. Farver, I'm going to start with you, and then I'll move to Mr. Brown.
Brown's got to be sworn first.
Yes, sir. Sorry.
Mr. Brown, if you raise your right hand, do you affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Ms. Farver, you're still under oath.
Thank you, sir. Ms. Farver, are you the same Mara Farver that appeared earlier today in this proceeding?
Yes.
And did you prepare or cause to be prepared 3 pages of rebuttal testimony that was pre-filed with the Commission on February 6th of this year?
Yes.
And as explained in your rebuttal testimony, your testimony adopts and incorporates by reference the blue highlighted section of the company's reply comments. Is that right?
Yes.
All right. And do you have any changes or corrections to your pre-filed rebuttal testimony at this time?
No.
And if I ask you the same questions that are in your pre-filed rebuttal testimony, would your answers be the same?
Yes.
Thank you. Chair Powers, I'd ask that Ms. Farver's pre-filed rebuttal testimony be entered into the record as if given orally from the stand.
The pre-filed rebuttal testimony, Ms. Farver, will enter the record as if given orally from the stand.
Thank you, sir. And I'm going to introduce Mr. Brown and then ask them to read their summary. So good afternoon, Mr. Brown.
Good afternoon.
Would you please state your full name for the record?
George Brown.
And by whom are you employed and in what capacity?
I'm self-employed.
Excellent. Thank you. Did you prepare or cause to be prepared 4 pages of rebuttal testimony pre-filed with the Commission on February 6th?
Yes.
And as explained in your rebuttal testimony, your testimony adopts and incorporates by reference the gray highlighted section of the company's reply comments. Is that right?
Yes.
And do you have any changes or corrections to your pre-filed rebuttal testimony at this time?
No.
All right. Now, if I would ask you the same questions that were presented in your pre-filed rebuttal testimony, would your answers be the same?
Yes.
Chair Powers, at this time, I'd ask that Mr. Brown's pre-filed rebuttal testimony be entered into the record as if given orally from the stand.
The pre-filed rebuttal testimony, Mr. George Brown, will be placed and entered into the record as if given orally from the stand.
Thank you, sir. Ms. Farver, if you'd please present your summary of your rebuttal testimony to the Commission, and then after you do so, if Mr. Brown could then please present his testimony summary.
Yes. The purpose of my rebuttal testimony is to adopt and incorporate by reference portions of the company's reply comments that are highlighted in blue. These sections respond to the South Carolina Office of Regulatory Staff's comment letter filed on December 5th, 2025, and support the company's application for approval of the 2024 Solar and Solar Paired with Storage Procurement Program. My rebuttal testimony first explains that ORS improperly dismissed the fact that the portfolio of solar resources procured through the 2024 RFP is priced lower than the solar reference cost in the company's Commission-approved 2023 IRP. As I explained in my direct testimony, the weighted average levelized cost of energy of the 2024 CPRE program winners was 1% lower than the assumed cost of solar resources in the company's most recently approved 2023 IRP. In other words, the cost of the portfolio of winners fell below the estimated cost of generic solar resources the Commission determined to be reasonable from a planning perspective in approving the 2023 IRP. This demonstrates that the results of the 2024 procurement are beneficial and cost-effective for customers. Despite acknowledging that the LCOE of the portfolio of winners was less expensive than anticipated and planned for in the IRP, ORS still argues that the solar-only costs were too expensive, focusing instead on a direct comparison between the LCOE for utility-owned projects versus third-party-owned projects. As witnesses Brown and Lee will explain, utility and third-party-owned solar are two distinct products. There are important qualitative differences between the two, including material differences in the optionality, benefits, and risks associated with each ownership structure, which render any direct comparison between the two misleading and improper. For this reason, the RFP evaluation design establishes a separate target quantity for each ownership and resource type. The CPRE RFP's objective to procure the highest-ranked, lowest-cost new solar is consistent with the way in which the General Assembly directs the Commission to evaluate a utility's IRP by considering the least reasonable cost considering the resources needed to support economic development and industry retention, and other risks and benefits. and not simply the least cost portfolio and selection of resources. As the independent evaluator recognized, you cannot fairly evaluate the RFP results by looking only at the LCOE for individual projects. Utility-owned resources and third-party-owned resources are different products, and comparing the two is not an apples-to-apples comparison. The independent evaluator's post-solicitation report specifically cautions against making such comparisons, as there are significant differences in contract length assumptions, optionality, benefits, and risks that come with owning an asset that you simply don't get through a PPA. In addition, ORS ignores the risk created by significant historical attrition rate for third-party owned projects. For example, of the 3 DEC and DEP solar procurement cycles that executed contracts between 2018 and 2022, 811 megawatts, or 65% of the PPAs from those 3 procurement cycles terminated. This high dropout rate puts at risk the company's ability to bring resources online that are needed to reliably serve our customers, and ORS's recommendation for 100% third-party ownership only heightens that risk. The companies also observed a high level of specifically PPA attrition in the 2024 RFP at the contracting phase, when 5 of the 10 PPA finalists and 1 PPA reserve list project, constituting 375 megawatts of third-party owned projects, declined their offers. Conversely, just 50 megawatts of finalists declined offers on the utility ownership track. Pursuing a balanced, approximately half-and-half ownership split provides protection for customers that necessary generation will be built and electricity will ultimately be delivered to the grid. Thank you.
Mr. Brown, if you'd please present your summary to the Commission.
Can't get my mic to work, sorry. Good afternoon, Commission. My rebuttal testimony adopts and incorporates by reference portions of the company's reply comments highlighted in gray and explains that ORS's recommendation to reject all utility-owned solar-only resources overlooks the system benefits of utility ownership and the General Assembly's policy favoring balanced ownership. I also address risks to the company's customers of relying solely on 100% third-party owned solar-only resources as recommended by ORS. I should note there are benefits from contracted resources, and the companies support a balance, a reasonable balance of PPA and utility-owned resources. With respect to the system benefits of utility ownership, it is prudent for utilities to own and operate generation that serves customers for a variety of reasons. For example, when the companies own a facility, they have complete control over it, meaning that they optimize its production without contractual limitations over its entire 35-year life for the customer's benefit, and can make changes to the facilities whenever it makes sense to do so. The companies can also control the facility's output and adjust usage as system needs change. In contrast, the company's operational control of purchase power is limited to the contractual terms and conditions of the PPA. In addition, because the companies are responsible for keeping the lights on across the system, customers benefit when the companies have direct control of and responsibility for maintaining a vast majority of its generation resources. While good contracts can create incentives for solid performance, independent power producers do not have the statutory obligation to serve customers. If a third-party owner's maintenance and repair costs go up enough, it can simply walk away from a contract with limited financial damage. Utility-owned assets are also subject to regulation and oversight by the Commission. In contrast, outside of a siting application, the Commission has no authority over third-party solar. The Commission does not have oversight as to how third parties operate their assets once they are in service. That lack of oversight is a risk when you rely entirely on purchase power, but one that can be balanced and mitigated by a reasonable share of utility-owned solar. Utility ownership also eases end-of-life issues. Because the companies have substantially more experience retiring assets at the end of their useful life, They are likely to be better able to adapt to changing circumstances and address new environmental rules about cleaning up sites than third-party owners. Finally, the companies can adapt utility-owned resources to incorporate future technology and system changes. There will always be technology evolutions that are not foreseeable today, but when the utility owns the asset, it can evaluate and deploy technology upgrades and asset modifications efficiently. With third-party assets, the contract terms may simply not allow the utility to require those kinds of changes. The South Carolina General Assembly recognized all of these benefits when it called for a reasonable balance of utility-owned and third-party owned resources in the Energy Security Act. Yet ORS's exclusive focus on a false comparison of the levelized cost of energy, LCOE, between utility-owned and third-party owned projects ignores these important system benefits. As solar becomes a bigger part of the company's generation mix, I believe it is essential that the companies own and operate solar facilities to provide greater reliability for customers and to ensure that the resource will perform as needed and not just buy power through third-party contracts. My rebuttal testimony also explains why ORS's recommendation ignores that reliability risks are amplified by selecting 100% third-party owned resources. Contract language only gives the company a limited right to dispatch down third-party resources and does not convey the same level of control the companies have over their own facilities. Under the 2024 CPRE program, Duke Energy Carolinas can only curtail third-party solar up to 5% of the forecasted annual energy, and Duke Energy Progress up to 10%. The company's own facilities are not saddled with those limitations. Beyond control, third-party resources carry greater reliability and performance risks in both the short and long term. Third-party projects fail to materialize at higher rates than utility projects, and it creates a real reliability problem when resources the companies are counting on do not get built. In addition, third-party ownership of contracted generation can present underperformance risk. While ORS says contracts adequately address performance risk, the company's real-world experience tells us risk persists even with such strong contracts. The companies can discourage underperformance through contract terms, but a disincentive is not the same as a guarantee. The companies have an obligation to serve their customers, even if the third-party resources underperform or never get built. While liquidated damages from a terminated contract may partially offset the financial harm of replacing the lost power, it is not the same as providing power when the system needs it. In the company's view, betting everything on third-party solar is not an acceptable gamble with system reliability. In conclusion, ORS's recommendation of zero utility ownership and 100% third-party ownership of solar is not reasonable on its face, and it is certainly not the reasonable balance the Energy Security Act calls for. Consistent with South Carolina law, the company's 2024 CPRE program procured roughly half utility-owned and half third-party owned resources. That approach balances cost, risk, and flexibility to deliver greater reliability for South Carolina customers. That concludes my summary of my rebuttal testimony.
Thank you, Mr. Brown. Mr. Chairman, the panel is available for cross-examination and questions from the commission.
Thank you very much. Any questions from SECIBA?
No questions.
ORS?
Yes. Good afternoon. Mr. Brown, are you aware of how many solar assets the companies have retired?
I am not aware of any solar assets the companies have retired. I don't think they've owned any long enough to have to retire them.
You just testified that they have more experience retiring assets.
Generation assets, yes.
So would you adjust that to say they have experience retiring generation assets but not solar assets?
Well, my statement was they have more experience retiring generating assets.
Okay.
I stand by that.
All right. All right. Ms. Farver, with the calculation of the solar reference cost, you state that these bundles came in 1% below that, correct?
That's right. The
Right.
weighted average solar-only cost of the portfolio of winners was 1% below the solar reference cost.
Right. When calculating that solar reference cost, were UOTs and PPAs both included?
Yes. So the way the solar reference cost is calculated is that it takes the assumptions, the cost assumptions from the IRP, and then it translates those to an LCOE. And there is a utility-owned LCOE and a PPA LCOE. And then the weighted average of those two is combined to create one solar reference cost. And that's the price that we benchmark against for the portfolio of winners.
Okay. Interesting. Apples and oranges, right? How many UOTs, again for you, Ms. Farver, UOTs from the 2022 and 2023 CPREs were terminated?
There were 2 utility ownership track projects in the 2023 RFP that were developed by a third party. They won on what we call the build transfer track. So the companies were going to acquire them when the mechanical completion was done. So the developer would build them all the way to the end, and then the companies would acquire the asset. For utility ownership track, during that 30-day contracting window, they sign a letter of intent. And so at that time, there was nothing binding about the letter of intent. Really, the binding agreement takes several more months, about 5 more months to fully negotiate. And so those 2 projects signed a letter of intent, and then the independent evaluator writes their post-solicitation report stating how many projects did sign their PPA or sign their letter of intent. And so we call them winners at that time. It may be a misnomer because there is still this additional time to execute the actual agreement. And so those 2 projects failed to sign their agreement. They were still within full control of the developer at that point in time. And this was actually a very valuable lesson learned because we realized that signing your letter of intent didn't have any additional skin in the game. And so developers weren't incentivized to get out early, and it sort of made sense for them to string us along and just fail to sign the later agreement. So we now have an additional deposit that's due at the time you sign the letter of intent, so that if you're going to decline early when we might still have a chance to select backup projects off the reserve list. So that was an important lesson learned.
Wonderful. And for that same period, how many PPA projects were terminated?
There has been, from the 2022 RFP, 1 PPA project so far. They terminated about 2 years after executing their PPA agreement. And looking at the cohort of projects before the 22 procurement, I believe there was a citation here in my summary here, but it was about 65% of the PPA megawatts from those procurements that were 2018 up through 2022 have terminated their PPA. So there were 2 utility ownership track projects during that time, that sort of earlier cohort of projects, and both of those are in service now.
So it's accurate to say that 2 UOT projects terminated from that period and only 1 PPA project terminated from that period. Is that correct?
There were 2 projects that failed to sign their agreement. I would characterize that differently as than terminated.
More questions? Thank you.
Thank you very much. Any commissioner questions? All right. Hearing none, you may step down. Any recross? Redirect, I mean.
No redirect. Commissioner Britt did have a question earlier that I neglected about the acreage of solar projects, and I think we were able to gather that information over the lunch hour. If it pleases the commission, I think Ms. Farber could provide an update on the South Carolina projects, if that's appropriate. I should have addressed that at the top, so apologies for coming in late.
If he wants to ask it again.
Yes, Mr. Chairman,
All right.
I do. Could you tell me the acreage on those projects?
Yes, the Sandhills project is about 400 acres. The Ponderosa project is about 480 acres. And the Mosley Creek project, which is North Carolina, is going to be about 600 acres, sort of behind the fence, as they say.
The second one was, what was it, Moser?
I'm sorry?
What was the second project? It was 480 acres?
Yes, about 480.
What was the name of it?
Ponderosa.
Ponderosa.
Mm-hmm.
Okay. Thank you. I appreciate it.
Thank you, Commissioner Brett. We've passed the time now that I've thought of a question. The 6 companies that declined, how much more would that have added to the number of megawatts?
So
Just roughly.
well, we made offers to 1311 and we ended up with 967. So I don't know if I trust myself to do the math fast.
Were there others about the same size?
So I might actually have the numbers in the confidential post-solicitation report, and I might just be able to lift out, present it non-confidentially.
Well, that's okay, because I don't know that it's relevant. Just,
Okay.
That was just my curiosity.
Yes, so it was 1311 minus 967.
Okay.
That was the megawatts of the number of projects that declined.
All right. Thank you very much. Any further commissioner questions? All right. Thank you very much.
Mr. Chair.
Mr. Vice Chair.
Before you all go, Mr. Brown, you are articulating the benefits of utility owned as opposed to third party through PPAs. Are you familiar with any experiences where with the third party where the utility, the company, realized that just with that experience with the third party, realized that utility owned would have some of the advantages that you testified to? Are you aware of any particular experience, specific experience, or are you speaking more in general terms?
No, we have experienced situations where third parties have not performed. They may have had an outage for a period of time, and I think they bring their equipment back if it makes sense to bring it back. They'll definitely do that, and they have done those kinds of things. But I think more of the experience I've seen is more they just don't materialize. The contracts, they execute the contracts in good faith. They think they can materialize, and then for a variety of reasons, they're unable to materialize. They just don't get into service.
And how is that detrimental to the utility, to the grid, and to the end user?
Well, we're expecting the energy. I mean, we're expecting that in our plans. And so if it doesn't materialize, then we have a hole that we have to fill. I'm not going to say it's necessarily going to create rolling blackouts or anything, but I'm just saying it's a problem that we then have to deal with because we are expecting it to materialize.
May I add on to that?
Sure.
There was recently an outage with a PPA that supports the South Carolina Shared Solar Program. And so in October, there was an operational interruption. And so little to no energy was being produced. And then that continued until they came back online on December 12th. And so there are about 200 customers or customer bills that are participating in that shared solar program. So they were not able to reap the credits from that program during the time the facility was down. So that's one example of, when a project's down, it may take some time to get back online, and there can be impacts to customers, certainly. And we have seen with the historic PPAs from the RFPs before 2022, we are seeing some underperformance compared to what the contracts had expected. And for those older contracts, the threshold was 70% of your annual production over a rolling 2 years. Before it became an event of, I can't remember if it's an event of default or penalties associated with it. So, you sort of have to, there's a time lag in that lower performance before contractually we can sort of take action and enforce those penalties.
Thank you. Thank you, Mr. Chair. That's all I have.
Thank you, Mr. Vice Chair. Commissioner Caston.
Mr. Brown, when you talk about some projects that didn't materialize, were there projects that construction had started or materials purchased and they walked away?
I'm not sure where they exactly were in their supply chain process. I don't know where they were when they stopped it, terminated the contract. I'm sorry.
Okay, I was just kind of wondering if it was just on paper or physically something, but okay, thank you.
Any further commissioner questions? All right, thank you very much.
Thank you. And Mr. Chair, may the witnesses be excused, please?
At their own risk.
Thank you. The company calls Mr. Bob Lee to the stand. Do we have his plate thing?
Mr. Lee, if you'll raise your right hand, please. Do you affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
All right. Good afternoon, Mr. Lee.
Good afternoon.
And Mr. Lee is the independent evaluator. I guess he'll introduce himself in more detail for the procurement, who's joining us from Boston. And so, recognizing his unique role as a witness in the case, we've presented his direct and his rebuttal testimony at the same time, since he's sponsoring his post-solicitation report, and then also, similar to the company's other rebuttal witnesses, presenting some of the supporting commentary in the reply comments. So just for that context for the commission. So Mr. Lee, good afternoon. Would you please state your full name for the record?
Sure, it's Robert John Lee.
Thank you. And by whom are you employed in what capacity?
I'm a vice president at Charles River Associates.
And did you prepare or cause to be prepared 5 pages of direct testimony pre-filed with the commission on February 6th of this year?
Yes, I did.
And as explained in your direct testimony, your testimony adopts and incorporates by reference your post-solicitation report that was filed with the commission, as well as purple highlighted portions of the application?
That's correct.
All right. And do you have any changes or corrections to your pre-filed direct testimony at this time?
Nope.
And if I ask you the same questions that you were asked in your pre-filed direct testimony, your answers would be the same?
Yes, it would.
Thank you. Chair Powers had asked that Mr. Lee's pre-filed direct testimony be entered in the record as if given orally from the stand.
The pre-filed direct testimony, Mr. Lee, will be entered into the record as if given orally from the stand.
Thank you. And Mr. Lee had a one exhibit, which was a confidential exhibit, Lee Direct Exhibit 1, that was the post-solicitation report for the RFP that was attached to his direct testimony.
All right, and that is a confidential version only?
This is a highly confidential, has all the bid price information in it, so yes, sir.
Okay. The confidential exhibit, known as Lee Exhibit 1, will be placed into evidence as exhibit number 12.
Thank you very much.
The confidential version shall remain confidential unless or until the commission rules that such information is not entitled to protection from public disclosure, or if the requesting party agrees that such information is no longer confidential or proprietary.
Very much appreciate that. I'm going to turn to introducing Mr. Lee's rebuttal testimony and then ask him to read both summaries sequentially. So, Mr. Lee, did you prepare or cause to be prepared 3 pages of rebuttal testimony pre-filed with the commission on February 6th?
Yes.
And do you have any changes or corrections to your pre-filed rebuttal testimony at this time?
No, I don't.
And if I asked you the same questions today that were asked in your pre-filed rebuttal testimony, would your answers be the same?
Yes, they would.
Thank you. Chair Powers, I'd ask that Mr. Lee's pre-filed rebuttal testimony be entered into the record as if given orally from the stand.
The pre-filed rebuttal testimony of Mr. Lee will be entered into the record as if given orally from the stand.
Thank you, sir. Mr. Lee, would you now please present your 2 summaries of your direct and rebuttal testimony to the commission?
Yes. Good afternoon. My name is Robert Lee. I'm a vice president in the energy practice at Charles River Associates, located in Boston, Massachusetts. Since 2010, my primary focus has been on the design and execution of procurement programs for electric utilities across the United States. Since 2022, the CRA team has worked under my direction as the independent evaluator for Duke Energy's annual solar procurement program, including the 2024 competitive procurement of renewable energy requests for proposal process under discussion here today. My direct testimony sponsors the 2024 solar and solar paired with storage procurement post-solicitation report dated August 29th, 2025, and Duke Energy has filed that as Exhibit 2 to its application. Through the 2024 RFP, Duke targeted 1,585 megawatts of solar energy resources. 535 of that overall target was intended to be solar only, with the balance coming from solar paired with storage options. Under the program, a minimum target of 400 megawatts of resources were to be located in each of Duke's Carolinas service territories. The RFP design also included separate solicitation tracks to procure utility acquisition, known as utility ownership track, and controllable power purchase agreement resources based on an overall ownership structure that seeked approximately 55% utility ownership and 45% controllable PPA track. Bidders were allowed to bid on an individual project under one or both solicitation tracks. Targets were subject to potential adjustment based on clearly defined market depth criteria and based on the solar reference cost derived from the cost of solar resources modeled in Duke Energy's 2023 Integrated Resource Plan. The process was competitive. 20 market participants submitted responses into the 2024 RFP across 77 projects. The RFP yielded bids for 5,688 megawatts of solar resources, including 1,300 of megawatts of proposals in DEC and 4,388 megawatts of proposals in DEP. The proposal evaluation process followed the same framework established through the 2022 and 2023 RFPs, including equally weighted economic and project risk components. It is proper to consider development and technology risk factors alongside with project economics because uncertainty related to things like in-service date, availability, output levels all directly impact the benefits accruing to customers. The bid evaluation mechanism used for all Duke Solar RFPs are broadly consistent with those used by CRA in other RFPs and other jurisdictions and meet industry best practices around transparency, definition, evaluation, and oversight as discussed at page 7 of the report. Bid evaluation progressed in 2 steps. The 2-step process was designed to advance a smaller set of projects for interconnection and analysis and cost review. It was important to cull the bids prior to interconnection cluster analysis to improve the interconnection cost estimates and minimize the timeline for that analysis. In step 2, the economics for shortlisted projects were updated to include interconnection costs prior to final ranking. Each solar-only PPA track proposal was evaluated on its 25-year LCOE. Solar paired with storage PPA projects were evaluated based on a 15-year LCOE evaluation horizon. UOT proposal LCOEs were derived using annual facility cost of service revenue requirements over a 35-year asset life. As the post-solicitation report explains at page 13, the difference in evaluation horizon alone make it impossible to directly compare LCOE across RFP tracks and technologies. The post-solicitation report explains that bidders in the 2024 RFP faced turbulent market conditions in late 2024 and early 2025. Under the new administration, the qualification requirements, magnitude, and timing of federal support for renewable generation was uncertain, tariff policies were volatile, and the high inflationary environment impacted the economics of projects bid into the RFP. It yielded the most complicated market conditions CRA has ever encountered in an RFP and led to deal attrition, particularly on the PPA track. As explained at pages 17 through 19 of the report, the top-ranking 45 projects were initially invited to advance to step 2 of the RFP. 21 of those projects declined the invite and were replaced by 18 additional projects, 12 of which also declined. In total, 30 projects advanced to step 2. 33 projects totaling approximately 2,581 megawatts were invited to step 2 that declined their invite. As explained in the results section of the report at page 22, 19 proposals totaling 1,312 megawatts were initially selected to proceed to the contracting phase as finalists versus an initial target of 1,585. The RFP did not meet the initial target due to the limited number of competitive proposals at the end of step 2. The weighted average solar-only reference price of the portfolio of winners was $76.61 per megawatt hour on a levelized cost of energy basis. The 76.61 price is 1% lower than the assumed prices of solar resources in the company's 2023 resource plan, or the solar reference cost. Overall, the post-solicitation report concludes that the 2024 RFP was open to all market participants developing solar and solar paired with storage in Duke Energy's franchise service territories in South Carolina and North Carolina, and that the 2024 RFP was conducted in a fair, transparent, open, and non-discriminatory manner.
Thank you. If you could now turn to the summary of your rebuttal testimony, please. Take a deep breath and then fire away when ready.
Sure. My rebuttal testimony sponsors Duke Energy's references to the post-solicitation report and Duke Energy's reply comments, which are sponsored by Duke Energy's other witnesses in response to the South Carolina Office of Regulatory Staff. The ORS reviewed the results of the 2024 solicitation and determined that in their estimation, the selection of 3 utility ownership track projects was not in the public interest, and their selection would result in an unreasonable increase in costs over and above what reasonably could have been selected. The basis for their conclusions was a review and comparison of project LCOE. Based on my review as the independent evaluator, their conclusions are flawed. An LCOE is calculated as the present value of project cost divided by the present value of project output in megawatt hours. While it's a commonly used tool in the industry, it has limitations, primarily because it's a measure of cost alone. There is no consideration of the relative value of the project's output. Because of that, a comparison of LCOE is only valid among projects offering identical or very similar value. For Duke's 2024 solar RFP, the post-solicitation report explains that the LCOE measure should not be used across RFP tracks or technologies because there are material differences in the values offered. These differences arise because of inconsistencies in factors such as contract term length, capacity value, facility optionality, risk associated with the expected output of each facility, and other factors. In this instance, even the output levels used to generate PPA prices are materially different from those used to value UOT LCOE. These differences are summarized in the reply comments and addressed on page 16 of the post-solicitation report, which concludes LCOE values across PPA track and UOT are not directly comparable. ORS suggests an alternative project selection based solely on the relative LCOE of projects without regard for the project's RFP track. I disagree with Duke Energy's position. I agree with Duke Energy's position and disagree with ORS's suggestion. It ignores fundamental differences in the calculation across tracks and technologies. As described in the post-solicitation report at page 16, this comparison, either individually or in the aggregate, may be misleading and improper. As I noted earlier, LCOE is the present value of cost divided by the present value of facility output. The post-solicitation report explains that the use of highly conservative output assumptions for the UOT projects raises the assumed LCOE for those facilities and those facilities alone. I agree with Duke Energy's assertion in reply comments that third-party PPA bidders use more aggressive assumptions than utility ownership track bids, which contributed to a lower LCOE for third-party projects as compared to utility-owned projects. Project evaluation for the 2024 RFP was based 50% on economics and 50% on non-price risk and other considerations as presented on page 12 of that report. The evaluation methodology was the result of an extended stakeholder process and is generally consistent with past precedent. Many of the low LCOE options identified by ORS scored poorly on non-price considerations and did not merit advancement to step 2 of the evaluation process. The development, risk, and technology categories are labeled non-price, but that does not mean they're not economic considerations. In-service date, availability, both have a direct impact on the value provided to customers and a direct impact on overall economics. I also confirm that the overall RFP was competitive and that 2 of the 3 projects selected in the utility ownership track were developed by third parties, Pine Gate Renewables and Cypress Creek Renewables, demonstrating competition between Duke Energy and third parties in this track. Thank you for your time today. I look forward to answering your questions.
Thank you, Mr. Lee. Mr. Chairman, Mr. Lee is available for cross-examination as well as commissioner questions.
Thank you very much. Sasiba,
No questions.
ORS,
We have no questions.
Commissioners, Commissioner Belson.
Thank you. Good afternoon, Mr. Brown.
Good afternoon.
Are you familiar with the ORS report?
Yes.
Are you familiar, I believe it's on page 5 of the report, where ORS compared the LCOE with the cost per megawatt from fuel case?
Generally, yeah.
Is that an appropriate comparison using LCOE?
So, I mean, I think in the sense that you're comparing the fuel cost savings where it's an uncertain value, fuel cost savings. It's the fact that fuel cost savings from that report may be based on past fuel prices is no guarantee that that would be equivalent to the fuel cost savings that would be offered by these projects.
But is that were they comparing that to fuel cost savings, or wasn't it a comparison to the calculated fuel cost in those fuel dockets?
I'm sorry, I'd have to go back and review the report to comment on that.
Okay. To the extent that it was comparison of the LCOE per megawatt hour to the calculated fuel cost for coal or gas in those dockets, would that be an appropriate comparison?
It would be a partial comparison, I believe, if it was on a dollar per megawatt hour basis of fuel cost, but there'd be other savings as well, like variable O&M costs and things like that, if solar output displaces thermal generation.
Okay, so there are further steps that need to be done for that comparison. Am I understanding you correctly?
Yes, with a vertically integrated utility like Duke, it's hard to understand the exact potential savings and from solar output without modeling the portfolio.
Okay, thank you. That's all, Mr. Chairman.
Thank you, Commissioner Belson. Any further commissioner questions? Vice Chair Williams?
Good afternoon, sir.
Good afternoon.
In your, I believe it was your Sir rebuttal testimony, you referenced the low LCOE options identified by ORS scoring poorly on the non-price considerations and did not merit advancement to step 2 of the evaluation process. Could you talk more about that?
Yes, there's 2 primary and one kind of secondary non-price evaluation factor. One was development risk, and one was sort of technology risk. Those categories evaluated how far the project is along in terms of steps towards achieving its COD date. It included things like the counterparty or developer experience in bringing projects online. On the technology side for UOT, there was preferred vendor lists and things like that, technologies in place. So those factors were all scored, and they were, and in aggregate, the non-price factors were given 50% of the weight of the overall scoring. LCOE within its track was given the other 50%. So those projects identified, they were scored as part of step 1 for non-price considerations. Those specific projects did not score particularly well. They were probably below the midpoint, but that was based on kind of a quick review, so I don't have exact scores to provide today. That's correct.
I'm sorry, you're an independent evaluator, correct?
Yes, that's correct.
So once this is over, you get to go back to Boston, right?
At some point, yes.
At some point, okay. So, when I'm hearing all this information and looking at the filing, I'm somewhat concerned that there may be an affordability or some will argue an inaffordability issue here that ORS is trying to bring to our attention. Do you have any comment based on my concern?
I do, actually. I think affordability is a big issue in the industry. It comes up with every one of our clients. It's important to Duke. but you can't really get at affordability from LCOE alone, and that's what the point I was trying to make at the beginning. It's a measure that includes only cost. It does not include benefits, right? So, for example, if we were looking at cost, every project category has a positive LCOE. Now, this is not a single project with a zero. There's not a single project that's negative. Why should we do any of these projects, right? They cost money. And the reason we do them is because they have benefits that outweigh the costs, right? So you can't compare the LCOE of a 25-year PPA to a 35-year ownership directly, because one provides 35 years of customer benefits and fuel savings. One only provides 25 years. It's an apples to oranges comparison, and it really isn't particularly meaningful. So I think affordability is a big issue. We're doing this to save, and doing the solar procurements to save customers money. That's where the solar reference cost comes in. And we're trying to get as many cost-saving projects as we can. But comparing individual projects across technologies or across tracks is not shedding any light on the benefits to customers.
Okay, thank you for sharing that. And again, you're the independent evaluator, and you may not be able to comment or respond to my questions, and that's fine. I'm just asking. I'm happy that you're here. So when you talk about the benefits, are there other benefits that have not been stated to your knowledge that maybe the commission has not been pointed to? Because we've been pointed to the costs, but there seems to be a question of what benefits come along with what has been testified to as higher costs, maybe unreasonably higher costs. Do you have any comments to that?
Yes. So I think we've talked quite a bit about the reliability, right, and the facility output. So to the extent that a PPA project doesn't meet the output target that was initially assumed for it, there's a loss of benefits to customers, right? That generation is going to have to be filled with some other sort of generation. Thermal, there'll be fuel costs, there'll be O&M costs. That's one. And another, I don't know that it's necessarily a benefit, but one of the other issues that we haven't discussed much is terminal value. So if I own a project, at the end of its useful life, there may be options, right? There may be ability to life extend projects. Some projects may be better than others and last a little bit longer than the 35 years that we initially thought. You may be able to repower with some other sort of generation at the end of the life. And there may be sort of a streamlined interconnection as a result of that. So there's all these benefits that may come at end of life for projects that Duke owns. Those benefits would accrue to the PPA counterparties on PPAs, right? So the assumed asset life for solar is about 35 years. The PPAs are 25 years. Those counterparties are likely expecting some sort of useful life for that facility at the end of the PPA. That's going to generate some positive revenue for those counterparties. That's all being captured by those third-party counterparties and contributes to their ability to be maybe a bit more aggressive on PPA pricing.
Okay, I'm glad you brought that up. Thank you. That's all I have, Mr. Chair. Thank you, Mr. Lee.
Thank you, Mr. Vice Chair. Any further commissioner questions?
One question.
Commissioner Caston.
Here. Where you talk about in your summary the differences arising in inconsistencies, contract term length, capacity value, facility optionality, risk associated with expected output. And then you talk about the output levels you generate PPA prices, and you reference in the, I guess, summary report or your report on page 16, the post solicitations report. The differences are summarized in the reply comments and addressed on page 16. Is that table 2?
I don't have the report in front of me.
It says reply comments. I mean, what I'm looking at just shows. I'm sorry? It is the post solicitation report he references.
Okay, the report itself.
These differences are summarized in the reply comments and addressed on page 16. I want to make sure I'm looking at the right page 16.
Do you have a clean copy? I've got a marked up copy of it all.
I'm just curious, is he referencing table 2, projects and megawatts submitted? Or is it on the watermark? That's not that.
So I believe it's in reference to page 16 of the reply comments, not the report.
Well, it doesn't clear up my understanding, at least it clears up that I didn't understand what that meant, but.
Okay. Is there something I could help clarify in terms of the benefits?
Well, you've listed it. I guess probably my next question would be better for ORS, on the 50-50, you look at the economic benefit, 50%, the non-economic other items, 50%. I was going to ask about that, but you've answered the question, and I don't need to know anymore.
Okay.
Thank you.
Thank you, Commissioner Cassidy. Any further commissioner questions? Any redirect?
No redirect. Thank you, sir.
Thank you very much. We kind of thought we were getting a little behind. I think if we keep going, we might could finish this by 6 or a little after, unless someone has an objection. The alternative is going to be to recess and come back Friday morning.
Mr. Chair, we were able to consult with Commission's counsel, General Counsel Ms. Hill, and our witnesses are available Friday morning at 9:30. And frankly, I don't know about y'all, I'm getting a little tired. We could have some fresh energy Friday morning and knock it out then if that pleases the Commission.
So Seba?
We're ready to finish it.
ORS?
We could finish today. We could go Friday.
Either way.
Are we polling commissioners?
All right. We are going to recess then until Friday morning at 9:30. Everyone have a good evening.
Thank you.
We are in recess.